Let's see here. What do I want to do? Let's do this. So I have some music playing in my ear. Keep a good cadence that way. All right. Give me just a second here, ladies and gentlemen. I like having a little music playing in my ear. Helps keep a good cadence when conveying information. And that's not what I wanted. There we go. All right. Welcome to The American Badass. Built on sound doctrines and principles, we sure hope that you will join our family. At the end, I'll give you a way that you can join the American Badass family if you wish to participate and you enjoy this content. The information I'm about to disclose and share with you guys is very pertinent and relevant, and any lying, looting, pandering attorney telling you otherwise is absolutely, wholly, and equivocally misleading you and full of shit. S-H-I-T. Shipment high in transit, right? So, our objective and our goal in disseminating this information is to help people ascend of the mind, to comprehend that things are not what they have been told they are or led to believe they are, and they don't function the way that they are purported to function. And all it takes is opening up a book and reading the literature. If you rely on other people's opinions to make your assessment without conducting a thorough investigation on your own, you will fall into folly. You will flounder. Just the same, if you don't build your own dream, I guarantee you, you will be building somebody else's. So The American Badass, built on sound doctrines and principles, is faith-based, not religious. It's spiritual-based, not religioning people. It's to help people ascend to the mind. And if we operate on sound doctrines and principles, ladies and gentlemen, and we walk with faith as a brother in Christ, a bondservant to the Heavenly Father, who can come against us? And the answer is nobody. If all men were created equal, and make no mistake about it, they were, because there are no hermaphrodites in man. No one created themselves. We are subject to the highest authority. People say, well, Derek, gee, golly, what you speak of sounds nice. It sounds like euphoria. Is it possible to achieve? And I say to you, absolutely. You see, if you don't like your form of government, government is a direct reflection of society. And so, in turn, what you're saying is, if the government has failed, society has failed. Well, I'll say to you, I love my government. Why? Because I self-govern. And self-governing comes with accountability, liability, and responsibility. You gotta have a little bit of pride, tenacity, determination to self-govern, because when push comes to shove, there's no one else you can count on. There's no one else to lean upon. It's incumbent upon you to stand upon your rights with vigor and vigilance and not waver. This is why prosecutors make plea deals, to see if you'll waver, to see if you'll enter into compact, contract, and agreement. Waive your rights. They make it easy to go along, to get along. Because by golly, if you don't make this deal, I've worked with the judge for years. He's going to throw the book at you. I've dealt with so many cases where they frivolously stack bogus allegations and statutory violations on top of cases just simply to get people to enter into a plea agreement. The information I'm going to disseminate to you today lays it all to rest. But you have to know it. You have to believe in it. The good Lord tells me, Derek, you got to have faith the size of a mustard seed. Believe in me, trust in me, and I will walk you through it. I'll be honest, there was times I carried a lot of doubt. And in the bottom of the barrel of despair, I had nothing left to lose and everything to gain, and I gave it all to him. So fuck it. I'm going to trust in you. I got no other options. I got nothing left. I believed in other men. I believed in groups of men. I believed in organizations, all of which have failed. Some built on sound doctrines and principles. Some built with a ton of integrity, but at the end of the day, they're all self-serving. They're all about their principle, their agenda, their bottom line, their profit and losses. Comprehending that grammar has a law that is similar, if not identical, to mathematics. Grammatically speaking, the law of grammar is precise and specific, just as mathematics is precise and specific. So knowing these things, comprehending them, understanding them, will lead you to be able to draw a conclusion for yourself, for which no other man will be able to convince you otherwise after digesting this information. Now, this information is not completed by any means. I use the work of an anonymous author, and I have added and contributed to it from my own personal experiences. Rest assured, almost every attorney out there will argue and have a point of conjectural bullshit to the contrary of what I'm about to show you guys. But facts cannot be denied. Let me rephrase that. There is no disputing with he who denies principles, so they can deny the facts all they want. But let us go back to the Pharisees. So it has been written, so it shall be done. So the American Badass built on sound doctrines and principles is only possible because of each and every one of you guys. I love you guys. I appreciate all the support, the prayers, the constructive criticism, the corrections when I stand in error or have made a mistake. None of this is possible without you guys. And the Heavenly Father being within each and every one of you, it's only by divine guidance I have achieved what I've been able to achieve, being about His good works. You see, when someone like myself prevails in court, I didn't win. The people prevailed. And the glory doesn't belong to me, because my purpose is greater than myself. All the glory goes to the Heavenly Father. And we quickly understand that when we realize the reason Lucifer and 1/3 of the angels were kicked out of heaven, whether it be metaphorically speaking or an actual event, is for you to exercise discernment and comprehend. But claiming ill-gotten gains and glory that doesn't belong to you will quickly have you cast out. So all the glory goes to the Heavenly Father for building us with broad shoulders. Brilliant, articulate thought process. You see, the lawyering craft, the attorneys, they practice what's called deviling, the twisting and manipulation of the language, to get you to concede to their will and their whim, to turn your rights over to something or someone else for their benefit. Ill-gotten gains, unjust enrichment, theft by way of false promise, honest services fraud. These fucking degenerate fucks know exactly what the fuck they're doing, and if they don't, show them this video, because this puts their dick in the dirt. So without further ado, the American Badass built on sound doctrines and principles proudly presents to you Memorandum of Law on the Name. Now, as I articulated earlier, this document was created by an anonymous source. Most often, these anonymous sources are people who are well versed and studied in law and at law, both lawful and legal. You know, you can violate the letter of the law all day long. Who cares? So what? The question becomes, yeah, I violated the letter of the law, but did I violate the spirit of the law? What was the intent of the law when it was created? A lot of these things people call law were created by men and women alike in a legislative political body that are no longer with us. And at the time, it may have made sense to pass some form of legislation pertaining to the subject matter. But should we all be hindered and burdened by the opinion of a body politic for a time that we've either outgrown or morally ascended beyond? You see, the only reason they pass statute after statute after statute and enact more bill after bill after bill is because their organization and entity, the way it's structured with this fiat legislation and fiat currency, and being that the people generally, the populace throughout the world, is not criminal in its nature, they're good by nature, they can't possibly justify all these attorneys, all these venues. They couldn't keep them busy without continually, perpetually creating benign statutes, codes, city ordinances, rules, and regulations that they enforce to extort you of your precious valued time commodity. You see, there's no money in the economy. The Federal Reserve knows that credits and debits on account are merely a way of exhibiting or expressing value. But what is the true value? What's the whole system predicated on? Your precious, valued time, commodity, and pledge of your future labor. Ladies and gentlemen, you are the pot of gold. You are the money. I was able to see this very easily at a young age after working for a feedlot. And as I started to study the law, I started looking at the familiarity and the similarity of a feedlot and these alleged entities and the way they're structured. It is the same way a cattle operation is run. Tag them, bag them, number them, vaccinate them, castrate them, manipulate them, herd them and move them, use controlled chaos to yield the results you want while providing the solution. It's nothing more than a gigantic feedlot. And the chutes for castration, branding, numbering, and all that are the court systems. You know, Jesus overturning the money changers' tables at the synagogues were supposed to be the house of the Lord, where the administration of equity was had. Justice being the goddess of war, right? So what do you mean, Derek? He changed over the money changers' tables and cursed them for turning his father's creation into property and merchandise and exhibiting pretend authority to charge interest on something they never created. That's exactly what it was. These courts were originally put in place and supposed to be subservient to a God-fearing government, to a God-fearing people, to a moral demographic of women and men alike. But that's not what we have today. We have greed, lust, fiat legislation, all meant to benefit a few and create controversy and turmoil while otherwise none exists. Just think about that for a minute. The statutory edicts are bills of attainder. You bring that up in one of their venues, Article 1, Section 8, Clause 9, or Article 4, Military Tribunal, and they'll scoff, they'll laugh. That's without merit You find me a court case that agrees with that, and I'll kiss your ass. Well, I know there's not a court case that agrees with that because I've gotten too many court cases dismissed and sealed because they don't want to rule on the subject matter brought before the court through demur or abatement because it would let the cat out of the fucking bag. They're not even going to go as far as letting somebody like me push that issue and making it an unpublished decision that you would have to go to the law library to dig out because it would absolutely destroy their facade and illusion of authority. I started paying attention to the memorandum of law on the name over 15 years ago. 70-year-old attorney and I had quite the relationship. When I called them out on their bullshit in the middle of the court, I did it with a lot of fucking bravado. And I was very hostile and fucking belligerent back then. I'm one of those people that doesn't start shit, but if it kicks off, I damn sure will fucking finish it. And I don't give a fuck if you're 7 foot tall or whatever the case may be. Don't start no shit, won't be no shit. But if you start the fucking war, rest assured I'm gonna finish it. And I watched all these attorneys snickering and laughing at what I was saying in the courtroom, acting like what I was talking about was nonsensical, illogical, of no relevance, without merit, no standing. Those are some of the words that were used. Crazy, delusional. Guy needs a mental health evaluation. I'm like, really? I need a mental health evaluation? You motherfuckers are running around stating that Kris Kringle, the Easter Bunny, the Tooth Fairy, somehow caused you harm, damage, loss, hardship, and an injury in fact, and that I need to stand in as surety and pay the debt of this fictitious entity that doesn't exist. It's a construct and figure in man's imagination and on paper alone. The 70-year-old attorney, a couple days later, I show up at his office. Years prior, I was always invited back into his office. Come on back, have a seat, let's talk. Because I was always fascinated with the aspect of law. What is it? How does it work? If it's so intricately woven within all of our lives and affects us at all times throughout our lives, how is it that none of us are taught what the law is from kindergarten to high school, from high school through college, if it's so important to know the law and so incumbent upon us to execute our duty to enforce the law? Why is it we are never taught the law? That attorney that day made me wait out in his waiting room. A little strange, a little unorthodox compared to our normal meetings and gatherings. I found it odd. I found it peculiar. I sat out there with the receptionist. 45 minutes went by. He finally came out. Normally his receptionist would say, he's ready for you, you can go on back. But that day was different. That day, I think he realized that there was no turning back and falling back in line for me after watching me in court. I know that he knew that I was coming to his office soon enough. It was just a matter of when. But what he had seen exhibited in court scared the shit out of him so much that he didn't want to be with me in private in his own office. Not because I was a physical threat to him. Or maybe because he may have perceived that I was a physical threat and just didn't want to risk it. Maybe he needed a witness for the things that were going to be articulated and said that day. He sat with me in that lobby and said, Derek, to the best of my ability, I will answer any question you have. But I need you to promise me that after our conversation today, you'll never come back. He said, I'm not saying you're a bad guy. I'm not saying that I'm in fear of you or anything like that. But you have to understand, I can't shit where I sleep. I can't shit where I eat. And the things that you're going to ask of me today, I'm going to tell you affirmatively. It doesn't matter how much money you have, I will not do it. I will not piss off the judge. I will not go in there and upturn that venue and create a mess for myself. So I started asking questions. I said, this whole system's bullshit. It's a scam. I said, people are being fleeced for victimless crimes. And at the time, I wasn't extraordinarily learned. I was reading a lot of statutes. Statutes are written vague and ambiguous on purpose. There's a lot of pronouns, a lot of adjectives, but no nouns. And I'm pointing this out to him. And he stops me about midstream and he says, you know, Derek, everything is 180 degrees backwards. It's inverted, meaning upside down, and all smoke and mirrors. And if you listen to what I say and you study really hard, you could defeat any action being brought absent an actual victim. I said, I'm listening. I'm ready. I thought it was going to be a long, drawn-out conversation. I figured there was going to be a plethora of explanations, and it was going to be like an algebra equation or geometry. To my surprise and dismay simultaneously, he said one simple statement. Everything you need to destroy a court case is on the first document you were ever served. 70 years old, 40 plus years in the field, in his craft. And he told me everything you need to defeat a case is on the first document you've ever been served from the court. I asked him to expand. I asked him to elaborate. He said, Derek, I've already said too much. He said, what you're doing is noble. It's honorable. Nobody will ever understand you in the community. So get used to being alone. And with that said, I got to ask you never to come back to my office again. He said, I discovered, Derek, what you were talking about and what you were just now discovering shortly after I passed the bar and graduated from law school. I said, so you know about this? He says, yes, I understand it and I know how it works. And I said, and at the same time, you're asking me to fall in line and not stand? He said, no, I'm not asking that of you. I'm warning you of the consequences of what come with standing in the light. Be ready for it. I'm telling you right now, they're going to find the deepest, darkest fucking hole they can stick you in. Not because you're wrong. Not because your assessment is incorrect. It's because they cannot allow you to expose what is true, correct, and accurate, not misleading. Because it completely destroys the system that they have created. You're messing with their money, Derek. That's what one of my mentors said. Yeah, what he's talking about is they wouldn't care if you were meddling with their wife and screwing their wife, but you screw with their pocketbook, buddy, and they will fuck your world up. That statement was later proven to be true. I was put in jail for asking questions, simply asking questions in a court. 7 days, contempt of court. Point of clarification. Is asking questions contemptuous? Do you want more days? 7 days. I said, objection, point of clarification. Is asking questions and seeking clarity on what is going on here so I can make an informed decision contemptuous in its nature? Bailiff, get him out of my courtroom. That was shortly after that conversation with that attorney that that transpired, and I realized that what he was telling me was true, correct, accurate, not misleading. There was no fucking way they were ever going to allow me to expose the bullshit that they're pulling on people. But it didn't stop me. I got too much integrity, too much discipline. If 1 million people are doing the wrong thing, does it make it right because the majority are doing it? Or do you have a duty and an obligation to stand up and go the opposite direction and say what you're innately doing, no matter how numerous you are in numbers, is wrong? You're engaging in moral turpitude. Be damned if it's for the greater good. Who gives a fuck about the greater good if the means to the end was nefarious in the beginning? Let those words sink in real fucking deep. Integrity, discipline, honor, discernment. These are the things money can't buy. These are the things that I speak of that are so valuable, you can't afford them. And yet, simultaneously, they're free. Isn't that amazing? Just like more time. So valuable, you can't afford it. So what they're really taking from you is your precious value time commodity. Under the false narrative of a fiat system that was designed from its inception to implode. I don't care what dynasty you look at. I don't care what monarchical system you look at. Every last one of them that's ever gone to a fiat system from the day of its inception had an expiration date. And this one that we're in has one too. It's fast approaching. It's coming quickly. The statutes, codes, city ordinances, rules, regulations, all these edicts, bills of attainder, bills of pain, guilty until proven innocent. It's coming to an end faster than most people think, but it requires a great mass majority to ascend to the mind. The Civil War, which is an oxymoron, there's nothing civil about war, was fought with less than 10% of the populace of the nation. It doesn't take 51%, as they allege, in a democracy to change anything, which they can't even prove they have 51% that have voted for this benign system. These deplorable fucks try to present under Vietas arms by way of threat of monopolized violence that they wield, that they have 51% controlling majority. So the 49% who stand out and say, fuck you, well, tough shit. And if you don't like the way we think, we have gun-toting morons with an IQ of 70 that'll come put you in your place. So let me arm you with the knowledge needed. Let me show you what I believe that attorney who was in his 70s, 40 years practicing, was talking about when he said, the only thing you need to destroy a court case, absent an aggrieved party, Derek, is on the first page that you're ever served with. Now, he wasn't talking about necessarily process of service or other due process violations. Not in my humble opinion, after doing a little research and thinking very intimately for about 4 or 5 years about what he was talking about. And that's where this memorandum of law in the name, created by an anonymous source, which I have altered and added to, with facts that can't be denied. Memorandum of law on the name. Many people are involved in diligent research concerning the use of Capitis Diminutio Maxima, the all caps name, like John Doe, in lieu of the Capitis Diminutio Minima. Now, it's imperative to comprehend. Derek, you're speaking a foreign language. Why? Why are you using Latin, the language of the dead? The language of the dead never changes. The definitions for the language of the dead written in Latin never change. English is a form of art, It's subject to change, the definitions, the structure, the way things are spelled correctly or incorrectly, right? But Latin's a different animal altogether. And according to scripture, we're not supposed to be using the language of the dead. But that should tell you everything you need to know right there, that these demonic people, individuals, are using the language of the dead. They're commingling French, Latin, English, and then have the audacity to ask if you can read English. And most people say, yes. I have a number of videos of alleged bench pounders saying, it's very clear that we don't speak English in this court. I'm not going to allow the argument of whether or not he understands or that he needs an interpreter because we speak a different language clearly in this court, and everybody knows it. We speak legalese. I have a number of different bench pounders recorded saying that stuff. So pay attention, because this is what I believe that attorney was trying to point out to me that day. In lieu of capitis diminutio minima, name in a proper noun, grammatically correct format. Remember, there are laws to grammar. They are concise. They are precise. They're either right or they're wrong. There is no in between, like the attorneys would like to tell you. Oh, well, that's a gray area. That really doesn't matter how it was articulated. Yes, it does. It's like reading schematics in a blueprint to building a skyscraper. You torque everything to specs. It's not a suggestion. It's exactly how it was designed and framed to be utilized. So pay the fuck attention, because what I'm about to show you is exactly that. The schematics and blueprint of a properly functioning system that benefits we the people instead of hindering we the people. The name of a proper noun, format grammatically correct, example John Doe. In all court documents, driver's license, bank accounts, birth certificates, etc., is the use of all capital letters to designate a name, some special English grammar rule or style. So in other words, is the use of the all capital letters name, does it create a trust, a fiction, a corporate entity, an estate? What exactly is the purpose of it, and where was it authorized? When was it contrived? When was it created? Who agreed to it, right? Is it contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? You know, see, these would be my affirmative defenses, part of my abatement maybe, even plausibly placed into a demur, these questions, right? Even structure them as negative averments or averments. Is this an official judicial or U.S. government? U.S. is an adjective, ladies and gentlemen, not a noun. It's an adjective, at best an acronym, but an adjective. Where does it get its controlling authority? It doesn't have it. U.S. government, rule and or style of grammar. Why do attorneys, court clerks, prosecutors, judges, insurance companies, banks, credit card companies, utility companies, etc., always use all capital letters when writing a proper name? I'm going to show you guys where it's all found. I'm going to show you the leading experts in grammar who follow the law of grammar, who write things like the Oxford English Dictionary or do the correctional edits in these dictionaries and sources of authority because they understand the law of grammar. And we're going to see what they have to say about this. I've always thought it'd be fun to subpoena a professor in English to a court to testify to the veracity of what the actual documents say and ask him, if you were to grade this document, never mind that it says court at the top or any of that stuff, let's pretend that this is just a document, and I asked you to grammatically correct all the deficiencies and errors according to the law of grammar and grade it, what would you grade this document? Is it legible? Is it something that can be comprehended without inferring or interpreting or presuming and assuming? And you know what they would do? There'd be a big fat motherfucking F with a red circle around the fucker saying it fails. It fails because it doesn't follow the laws of grammar. And therefore, the document literally says nothing. Not a fucking thing. And I strongly believe that this is what that 70-year-old attorney was trying to point out to me when he said, all you need is the first document from the court and you can destroy the case. That's all you need. It goes a little deeper than that, because I'm going to point out some other things that are typically on the first page of the document, and also the complaint or information. A complaint and information only applies to agents and agency under the law of agency. Information only applies to government agencies and agents. A claim is what a man makes. A man makes a claim. Corporations file complaints. They whine, they quibble, they hire somebody to whine, quibble, and bitch on their behalf. Right? And then an information filed before the court. And I just dealt with this the other day in court. The judge was like, well, the information. I'm like, yeah, I know what you're saying. Far be it from me to make issue with that. Although I could. It's minuscule in its nature, but it's nice to have in your arsenal. Does an information apply to a man? Not the public, because the public is not man. It's not the people or a people at large. The public is the businesses. The public is the entities. Law is extremely precise. Every letter, capitalization, punctuation mark, etc. in a legal document is utilized for a specific reason and has legal, i.e., ergo, deadly force consequences. There's a reason I'm highlighting that. You can have a paragraph, and mind you, I dropped out of school at 13. English was not my strong point. I had to teach myself how to read, write, and learn the law of grammar, and I'm still not an expert by any means at it. However, it was one of my mentors that pointed out, did you notice that they made an amendment in the statute at large to Section 16, Part 5, A and B? Did you see the correction that they made? It shall now read, and I'm reading it, and I go, it says the fucking same thing, dude. They didn't change anything. He said, no, go look at it again. I'm looking at it. I give up, man. I give up. I'm looking at it. It says the exact same fucking thing. He goes, no, it doesn't. And this is where your lack of intellectual knowledge or acquired knowledge gained in grammar is causing you a deficiency that is stifling you from gaining the acquired knowledge to stand squarely on the topic. He said, you see they moved that comma? And they went from and to or, and they moved that comma? I go, yeah. Now read it. I'm reading it. I go, it says the same fucking thing. He goes, no, it doesn't. By moving that comma, they changed the entire subject matter of that entire paragraph. It has been reconstructed and no longer states what it once stated because the moving of that comma and it going from and to or, it changed the entire paragraph. So although the words all appear to be the same, just moving that comma and changing one word changed the entire structure and the entire intent and purpose of that paragraph. And it blew my fucking mind to realize that's how simple it is. But there's laws to grammar. And they're following the laws to grammar, ladies and gentlemen. Rest assured that. And then, of course, they're manipulating it. And at the same time, not following the laws to grammar and getting people to come in and consent through manufactured consent knowing that people are illiterate. And if you're illiterate, then you have to be governed over. It's in the interest of the public to make sure that somebody that is unlearned is lorded over and looked after so they don't cause harm to the literate folk. The law is extremely precise. Every letter, capitalization, punctuation mark, etc. in a legal document is utilized for a specific reason and has legal, i.e. deadly force consequences. If, for instance, one attempts to file articles of incorporation in the office of the Secretary of State of a state, if the exact title of the corporation, down to every jot and title, is not exactly the same each and every time the corporation is referenced in the document to be filed, the Secretary of State will refuse to file the papers. Ladies and gentlemen, I learned that with firsthand perfected knowledge. I started tinkering around trying to create my own corporate entities and what have you years and years ago. And I didn't realize that the law is specific and the words have to be precisely executed. And so I'm trying to create this corporation, and every time that I'm writing the name of the corporation, sometimes I'm doing it in proper case, sometimes I'm doing it in all caps, sometimes I'm putting on the end of it LLC, and other times I'm not. And all the documents keep getting rejected, and I can't find out why. I just can't make heads or tails of it. Why the fuck is the Secretary of State refusing to christen this with a state seal and bless it so I can run a legitimate business? I'm trying to do the white thing. I mean the right thing, according to their bullshit. And here I keep getting refused and refused and refused. Later on, I discovered that every time that I was submitting these documents, and they'd comb through them and they looked for these discrepancies, and every time the name was spelled wrong, or it wasn't in the proper style, wasn't necessarily that it was spelled wrong, it wasn't in the proper style, then they were denying it. I eventually had to hire an attorney because I couldn't figure out what I was doing. Paid him $200. Took him all of 35 minutes, and he called me up. I expected it to be a 2-week process. He called me up. He's like, "It's done. Come on down here. We just got to publish it in the paper. You're good to go." I go, "What did you do different than me?" He's like, "Well, you see, there's a format and a structure here, and you weren't following the format and the structure." Really what he was telling me is the way that you styled things differently over and over and again prevented the Secretary of State from accepting the articles of incorporation, articles of association, so on and so forth. So, good news. It only cost you $200, a couple of weeks of wasting your time, and 30 minutes for you to get a legitimate company. Come on down and pick up your paperwork. We're going to publish it in the paper. You got your EIN and everything already? Did that on my own. And he said, and now publish it in the paper. Go get your bank account. You're good to go. So, again, let's go over it one more time. If, for instance, one attempts to file articles of incorporation in the office of the Secretary of State of a state, if the exact title of the corporation, down to every jot, every insignia, every period, comma, whatever it is that you're integrating into the name of your organization, if it is not precisely there each and every time the exact same way, they reject it. Down to every little jot and title is not exactly the same each and every time the corporation is referenced in the document to be filed. The Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. This is important. Why? Well, I've been involved in criminal litigation. I've been involved in civil litigation. I've been involved in a couple of different venues as far as the exclusive jurisdiction of equity, and the pleadings and the way that they do things are different in different venues. But one thing that I've noticed is, like, civil litigation might say Derek S. Gonzalez. Criminal litigation might be Derek S. Gonzalez or just Derek Gonzalez, right? And so all these little nuances, these things that just seem like oversight, maybe a Scribner's error, actually have purpose and meaning and they're protected underneath trade secrets. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation's identifies an entirely different legal person. Legal person. All these entities in the fictions are legal persons. Legal persons is a generalization for trust, joint business partnership, ventures, co-ops, LLCs, S Corp, C Corps, all kinds of different things. These legal juristic persons, all right? Can't operate in commerce without having a persona, a mask, if you will. Commerce is war, and naturally it's governed by the law of war and the military war manuals, as well as the law of mercantile and the Trading with the Enemy Act. It's all war that's being waged on the people, a war of great deception. It is therefore an eminently valid and possibly crucial question as to why governments, governmental courts, and agencies purporting to exist in some undefined, unproved manner within the jurisdiction of this state. Remember, I keep pointing to you guys, in all 50 state statutes, you will find, typically within the Department of Transportation Code, but it is also found elsewhere in other states, where it says, in this state, in the state, is the exterior territorial boundaries of a state. When we look at the law of grammar, when it says a state, it means there are multiple states, and we're not talking about the 50 states, we're talking about multiple states that look similar to, possibly even identical to, Nebraska. And so you have state of Nebraska, and then you have Nebraska. You have a federated state and a confederated state. The federated state is limited to, via the statute, in this state, in the state, the exterior territorial boundaries and borders of a state. Okay? Within the jurisdiction of this state, insists on always capitalizing every letter in a proper name. For purposes of understanding one's legal or commercial status under the admiralty system, the law system used in England, Canada, and much of the U.S., it is necessary to examine the curious use of the all caps capitis diminutio maxima in legal and domestic income tax forms, credit cards and statements, loans, mortgages, speeding and parking tickets, car documents, road tax, court summonses, etc. While seemingly a trite concern, this apparently small detail has extremely deep significance for everyone listening. What English Grammar Reference Book says, Manual on Usage and Style, one of the reference books obtained was the Manual on Usage and Style, 8th edition, the ISBN, the book number so you can find it, published by the Texas Law Review in 1995, Section D. Capitalization, paragraph D, 1:1 states, always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things. Ergo, Dan, Austin, Rolls-Royce. Paragraph D, 3:2 of Section D states, capitalize people, state, and any other term used to refer to the government as a litigant, ergo the people's case, the state's argument, but do not capitalize other words used to refer to litigants, ergo the plaintiff, defendant, Mason. Gage Canadian Dictionary, 1983, Section 4, defines capitalize adjective as to take advantage of, to use to one's own advantage. Now, this might be an important time to let you know the etymology of attorney is to attorn property from one and grant to another. Most people have this preconceived notion that property is only physically tangible. Toothbrush, car, house, boat, plane, train, automobile. Let me help you adjust that preconceived notion. Rights are property. You have tangible and intangible rights. A lot of times when they're alleging the violation of some statute, they're alleging that their entity, that the alleged state, you have trespass on a right of the state, causing an injury to the state. Although it may be inconceivable, because we all know that inanimate things and objects don't have rights. If it doesn't have a heartbeat, a pulse, appendages, phalanges, exercise cognitive thought process, doesn't have rights. Now, there's going to be a bunch of attorneys that are about to shit themselves. Oh my gosh, it absolutely has rights. 14th Amendment! 14th Amendment! Citizens United! Citizens United! It's fucking amazing to me. You can't hurt a corporation. You can't hurt an entity. They're structured for commerce, profit, and gain. And there's processes structured within the system to ensure that you can't cause harm, damage, loss, hardship, or an injury, in fact, to a corporate structure or entity. They just write it off on their taxes, and they get tax credits, and they're compensated for the discrepancy in the bookkeeping entries. And your entity, therefore, incurs a tax liability. Oh, the things they fail to tell us. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reason. In either ignorance of the law is no excuse, or violation, one violating the law henceforth on others is acting under title of nobility and abrogating the principle of equality under the law. They continue to write plaintiff defendant. Ladies and gentlemen, if I may direct your attention to, I believe it is the Federal Rules Civil Procedure 17. Let's see. Federal Rules Civil Procedure Rule 17. Sorry, I got to do this on the fly. Let me just pull this over for you so you can see it. Right here. Plaintiff and defendant capacity, public officer. Are they presuming and assuming that you're a public officer? That you're the surety and trustee for the public debt? And if so, why are they not disclosing that to you so you could properly offset or set off the charges? Oh, folks, this is how they run away with the rents, profits, proceeds, futures, and annuities in this fictional fiat monetary system under fictitious and fiat legislative authority. So again, to attorn or attorney, etymology is to attorn property from one and grant to another its principal, typically, or itself. And in the Gage Canadian Dictionary, 1983, Section 4 defines capitalized adjective as to take advantage of, to use to one's own advantage. Now remember, the reason that I'm drawing your guys' attention to this is because that 70-year-old attorney who had had 40 years in the field said, Derek, all you need to destroy an action against you is on the first document you were ever served by the court. And it took me years. I asked him to expand. He would not. He said, you're a smart guy. You'll figure it out. I've already said too much. Please don't come back to my office. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual. This is important. The law style manual. Style, talking about the grammatical law, the style, okay? The proper grammatical format that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. You see? So, which lie is the truth? Either you haven't read the manual and you're derelict in your duty, absconding from your duty, taking your income under false pretenses, or you're deliberately, knowingly, willingly, and intentionally violating it, causing harm, damage, and loss, granting rise to punitive damages and actual damages. Which lie is the truth, Judge? Which lie is the truth, prosecutor? Which one of you fuckers carries a primary active degree of fault amongst joint tortfeasors? Whose nuts do I nail to the wall first, motherfuckers? And either ignorance of the law is no excuse. Of course it's not. Or violation, one violating the law he enforces on others is acting under title of nobility. Title of nobility was abolished, ladies and gentlemen. We were warned about that in the 4 organic laws of the United States of America. The Articles of Confederation, the Declaration of Independence. We were warned about titles of nobility and how fucking dangerous they are. And abrogating the principle of equality under the law. Well, if they're operating under a fictitious system while failing to disclose the rules of engagement, are they operating and treating us as enemies under the Trading with the Enemy Act, where they're allowed to lie and deceive and create artifices and schemes to unjustly enrich their principal under the guise of safety or the best interest of a child? They continue to write plaintiff defendant, the state of Texas. I'm going to show you the importance of this because when he told me everything you need, Derek, to destroy a court case is literally on the first page they ever hand you. See how it's all capital, the state of Texas? I'm going to show you the controlling authority that says this right here is grammatically incorrect, and as such, through a process called abatement, we're going to draw it to the attention. Remember, if you see an issue and don't make issue with the issue that you see that is incorrect, you waive the issue, and under maritime admiralty, under the law of mercantile, underneath the DOD, they're allowed to presume and assume that everything in the information or pleadings is correct and that the quote-unquote defendant waives all affirmative defenses and defects, and they proceed on. Let me say it again. When you see an issue, it is your duty and incumbent upon you to raise the issue or you fucking waive it. And proper names of parties in all capital letters on every court document. Black's Law Dictionary, revised 4th edition, 1968, provides a more comprehensive definition as follows. Capitis diminutio, meaning the diminishing of status through the use of capitalization. In the Roman law, a diminishing or abridgment of personality, a loss or curtailment of a man's status or aggregate of legal attributes and qualifications. Remember, there's a difference between legal and lawful. Lawful, we're dealing in reality. Legal, strictly fiction. All right? Notice how it's talking about the Roman law. Under the Judicature Act, the blending of equity and civil law or civil statutes is where they were blending Roman civil law, Roman civil equity, all right, and Roman civil maxims, which are not the same as the exclusive jurisdiction of equity spoken of in Article 3, Section 2, Subpart 1. The exclusive jurisdiction of equity can never be destroyed. It's the law of nature and nature's God. It's built on sound doctrines and principles that man have discovered through the ages that are indisputable. No matter how much they don't like it, those facts will always remain the fact. But under the Judicature Act, when they blended the laws, right? They did it under Roman civil law, Roman civil equity, Roman civil maxims to bolster and press upon the general populace and their ignorance commercial law, the law of mercantile, maritime admiralty. A diminishing or abridgment of personality. See, do you have a driver's license? Nope, sure don't. The estate has a driver's license. I merely lend and extend my personality and life source energy to it. But I don't own it, and it doesn't belong to me. It belongs to the state or estate. Right? Do you have a birth certificate? Nope. That belongs to the estate as well. Right? I might give it a personality. I might extend my life source energy to it. But aside from that, I have no ownership of it. Who carries the primary active degree of fault for the thing you're administering in rem, either in a judicial setting or quasi-judicial setting? Who owns it? Who carries the liability for it? You give energy and action to it and a personality to it, but you don't carry any liability for it. The owner does. A loss or curtailment of a man's status or aggregate of legal attributes and qualifications. This is going to piss off so many fucking attorneys. It's not even funny. English Grammar and Style reference book is found only one reference to capitalization located with the glossary at proper noun, page 94, where it states, the name of a particular person, Frank Sinatra, place, Boston, or Moby Dick, proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. Capitis diminuitio minima, meaning a minimum loss of status through the use of capitalization, ergo John Doe. The lowest or least comprehensive degree of loss of status. This occurred where a man's family relations alone were changed. It happened upon the arrogation, pride of a person who had been his own master, sui juris, of his own right, not under any legal disability, or upon the emancipation of one who had been under the patria potestas, parental authority. It left the rights of liberty and citizenship unaltered. Capitis diminuitio media, meaning a medium loss of status through the use of capitalization, ergo John Doe. A lesser or medium loss of status. This occurred where a man loses his rights of citizenship, but without losing his liberty. It carried away also the family rights. And last but not least, capitis diminuitio maxima, meaning of maximum loss of status through the use of capitalization, ergo John Doe or Doe John, the highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage. When he became a slave, it swept away with it all rights of citizenship and all family rights. What English grammar experts say. One of the foremost authorities on American English grammar, style, composition, and rules is the Chicago Styles Manual. The latest 14th edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of written or printed text. Since we can find no reference in their manual concerning the use of all capitalized letters with a proper name, or any other usage, we wrote to the editor and asked this question. Is it acceptable, or is there any rule of English grammar to allow a proper name to be written in all capital letters? For example, in my name, if my name was John Paul Jones, can it be written as John Paul Jones, all capital letters? Is there any rule covering this? The editorial staff of the University of Chicago answered, writing names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if Gone with the Wind appears on the title page all in caps, we would properly render it Gone with the Wind in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrative to preserve the casing of the letters. We are not sure in what context you would like your proper name to appear in all caps, but it is likely to be seen as a bit odd. Law is extremely precise. Every letter, capitalization, punctuation mark, etc. in a legal document is utilized for a specific reason and has legal, i.e. deadly force consequences. If, for instance, one attempts to file articles of incorporation in the office of the Secretary of State of a state, if the exact title and of the corporation down to every jot and title is not exactly the same each and every time the corporation is referenced in the document to be filed, the Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. I think now would be a good time to explain to you that before a trust can ever be manifest into existence, an estate must exist first. So the application for birth registration, probated by the state registrar, the chief probate officer, created, in fact, the estate. And from that point on, all these administrative agencies are creating constructive trusts using a different structure of the estate name to create the constructive trust to create an attachment to the estate. You can have an estate without trust, but you can't have trust without an estate. An estate must always exist first. And that's the first thing that is probated, is the estate. Okay? And the evidence of that, and don't take my word for it, but go look up what the state registrar's duties are. And then, if you're really intuitive, you'll go look up every state registrar that intrigues you, and you'll look up their educational background. And you will find that state registrars typically have a PhD or a master's degree or a JD in trust law. Wonder why that is. I guess if you're going to fill the position of creating estates and understanding what you're doing, it might be incumbent upon you to have the acquired knowledge of how to properly execute and create those things and manage and maintain those things, right? It is therefore an eminently valid and possibly crucial question as to why the governments, governmental courts, and agencies purporting to exist in some undefined, unproved manner within the jurisdiction of this state insist on always capitalizing every letter in a proper name. Now, I know I'm being redundant. I'm being rhetorical. Like I said, I'm remastered this document. It was originally only like 10 pages long. I've got it turned into 25. And by the end of it, I think that you will comprehend what's going on. By the end of it, you may come to the same conclusion that I have, that attorney in his 70s who had been 40 years in the field told me everything you need to destroy a court case is on the first document they ever hand you. He wouldn't expand on it, but I'm pretty sure by the end of this 25-page document, you're going to know exactly what he was talking about, because I sure believe it to be true. Although there are more than just the grammatical style issues on the first document, there are other issues, but this is a prominent one. Remember, under the doctrine of idiom sonum, dissimilar things should not be joined, and similar is not same, but under the doctrine of idiom sonum, if it looks the same and sounds the same, they presume and assume it to be the same. It's incumbent upon you to correct the error, whether you do abatement, whether you use demur. Those are two tactical tools that you could use in order to get the record corrected, because remember, in the court, there are no facts and no law that will ever be tried in a court. None, ever. So the court is predicating its decision on the record being maintained. And of course, they muddy the waters and create a bogus record. And if you're not intuitive enough and quick enough to correct the record and make issue timely, then you waive the issue, and therefore they presume and assume laches occurs and you hereby consented and da-da-da-da-da. You know, there's a bunch of learned people here on Facebook that join us. They comment a lot. I see their point of contention. It's not necessarily conjectural. They're pointing out procedural things. I'm very unconventional when I interact with these people, and I yield very positive results by the grace of the Heavenly Father. And I won't go as far to say that anyone in particular within the legal sphere is in fear of me or what I can do or what I can't do. Ultimately, it boils down to moral turpitude, moral compass, and moral fiber at the end of the day. I think a lot of them, because most of what I do is oral in a courtroom. I very rarely file many documents, if any documents at all. In fact, the last hearing that I just had, it was all oral. There wasn't anything. I mean, there were some documents filed, but I already knew what they were going to do. Objection, sustained. Are we going to deny this motion? Yep, figured that. I already knew that. But the thing that grabbed them by their balls, the short and curlies, procedural violations and due process violations articulated orally in a notice of liability if you proceed further. It's an act of aggression and transgression, causing harm, damage, loss, hardship, and an injury in fact. You now knowingly, willingly, and intentionally are moving forward, comprehending the full weight and scope and veracity of the atrocity that you're perpetuating on the defendant, and therefore carry the primary active degree of fault. Checkmate. Your move, motherfucker. What you want to do. How you want to play. Then comes a barrage and myriad of questions. So you're saying due process was violated. How so? Just testing me to see whether or not I have enough knowledge and I'm well spoken enough to articulate it to a jury of 12 to get paid. That's all. Just a test. Is he articulate enough to nail my nuts to the wall? Because I'm wagering right now. I'm gambling on whether or not he has the testicular fortitude and the tenacity to move forward and actually create an attachment onto my juristic person as well as me personally and liquidate my assets. Does he have the acquired knowledge or does he just talk a big motherfucking game? They're wagering. Because every verdict and sentence they cast down, they get a kickback. That's why they got to file a 1099-R with the IRS, and the courts have to file the 1099-Cs, A's, and B's because they're engaged in business, commercial activity for profit and gain. They're glorified pawnbrokers, dealers, negotiating securities intermediaries. They're supposed to be doing it on your behalf and for your benefit. But the people fell asleep at the wheel. And they quickly realized they could rape, rob, loot, and plunder the American people due to the fact the American people are vastly ignorant and illiterate. It is therefore eminently valid and possibly crucial question as to why the governments, governmental courts, and agencies purporting to exist in some undefined, unproved manner within the jurisdiction of this state insist on always capitalizing every letter in the proper name. Mary Newton Bruder, Ph.D., also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question. Why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc., spell a person's proper name in all capital letters? For example, if my name is John Paul Jones, is it proper at any time to write my name as John Paul Jones, all capital letters? Dr. Bruder's reply was short and to the point. It must be some kind of internal style. There is no grammar rule about it. It seemed that these particular grammatical experts had no idea why proper names were written in all caps, so we began to assemble an extensive collection of reference books authored by various publishers, governments, and legal authorities to find the answer. The Element of Style. Another well-recognized reference book is The Element of Style, 4th edition, written by William Strunk, Jr. and E.B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book is found only one reference to capitalization, located within the glossary at proper noun, page 94, where it states, the name of a particular person, Frank Sinatra, place Boston, or Moby Dick, proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. This doesn't just apply to your name, ladies and gentlemen. Go look at the pleadings. Go look at the summons, and you will see the state's name is in all capital letters too. And I'm going to show you why that's important. I firmly believe what that attorney was trying to show me was so blatantly obvious and in my face, but I couldn't wrap my head around it because I didn't have this acquired knowledge here from leading experts. Remember, their testimony in a court is nothing more than hearsay, but because they're experts and licensed and have these accolades behind their name, the court can receive their testimony even though it's nothing more than hearsay because they're considered experts in their field. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. The American Heritage Book of English Usage, a practical and authoritative guide to contemporary English, published in 1996, at Chapter 9, Email, Conventions, and Kirk's Informality, states, to give a message special emphasis, an emailer may write entirely in capital letters, a device emailers refer to as screaming. Some of these visual conventions have emerged as a way of getting around the constraints on data transmission that now limit many networks. Here's the reference source within contemporary modern English that states, it is of an informal manner to write every word of, specifically, an electronic message, aka email, in capital letters. They say it's screaming to do so. By standard definitions, we presume that it is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happened to the decorum of a court if everyone is yelling? Is the insurance company screaming at us for paying the increased premium on our policy? This is doubtful as to any standard generalization, even though specific individual instances may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys and the court supposed to be specific, formally writing all legal documents to the letter of the law, not just the statutory necessarily legislative law, but the law and rules of grammar? All right? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? Diminuotio, Latin in civil law, diminuotio, a taking away, loss or deprivation, capitit, by the head. As Black's Law Dictionary explains, the full capitalization of letters of one's natural name results in a diminishing or complete loss of legal or citizenship status, wherein one actually becomes a slave or an item of inventory. The method by which the state causes a natural person to volunteer himself into slavery is through forming legal joinder, implied or stated. With the entity or legal fiction named of all caps, of course, most natural persons wouldn't willingly form such an unlawful but legally reductionist joinder, so trickery and obfuscation are used, and this starts when the birth certificates are created. New Oxford Dictionary of English. The New Oxford Dictionary of English is published by the Oxford University Press. Besides being considered the foremost authority, again, the foremost authority on the British English language, this dictionary is also designed to reflect the way language is used today through example sentences and phrases. We submitted the following definitions from the 1998 edition. Proper noun, also proper name. Noun, a name used for an individual, person, place, or organization spelled with an initial capital letter, ergo, Jane, London, and Oxfam. Name, noun. 1. A word or set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is Parson, John Parson. Kowalser is the German name for lime water. Verb 2, identify by name. Give the correct name for the dead man has been named as John McIntosh. Phrase 3. In the same of bearing or using the name of a specified person or organization, a driving license in the name of William Saunders. From the Newberry House Dictionary of American English, published by Monroe Allen, Publisher, Inc., 1999, name. A word by which a person, place, or thing is known. Her name is Diane Daniel. We can find absolutely no example in any recognized reference book that specifies or allows the use of all capitalized names, proper or common. There is no doubt that a proper name, to be grammatically correct, must be written with only the first letter capitalized, with the remainder of the word in a name spelled with lowercase letters. U.S. Government Styles Manual. Is the spelling and usage of a proper name defined officially by U.S. government? Yes, the United States Government Printing Office, in their Styles Manual, March 1984 edition, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all government publications, including court and legal writings. Ladies and gentlemen, the United States Government Styles Manual is what they use in the legislature to draft and create the bills. The words, the terms, everything has to be defined before they create or construct or draft the bills for legislation and legislative approval. All right. So the Government Styles Manual is quintessential. It's important to have in your arsenal, because if it wasn't written pursuant to the government's official printing styles manual, then how could we ever definitively say the intent of the structure of the statute is this? So the words have to be defined. The style has to be defined. Everything about it has to be correctly identified, so that when they're drafting and drawing up these bills, they're doing so very specifically and within the scope and the authority of the words defined by the Government Printing Office Styles Manual. All right? Chapter 3, Capitalization at 3.2 prescribes rules for proper names. Proper names are capitalized. Example given are Rome, Brussels, John McAdam family, Italy, Anglo-Saxon. At 17, court work. The rules of capitalization, as mentioned in Chapter 3, are further reiterated. 17.1, court work differs in style from other work only as set forth in this section. Otherwise, the style prescribed, pay attention to this, the style prescribed in the preceding section will be followed. All right? Meaning that when we're dealing with a proper noun, it's got to be done in this style. All right? So they're referring back to 3.2 in the Government Styles Manual, the Government Printing Office Styles Manual. All right. After reading 17 in entirety, I found no other reference that would change the grammatic rules and style specified in Chapter 3 pertaining to capitalization. At subsection 17.9, this same official U.S. government manual states, in the titles of cases, the first letter of all principal words are capitalized, but not such term as defendant and appellee. This wholly agrees with the Texas Law Review Manual on usage and style as referenced above. Examples shown in subsection 17.12 are also consistent with the aforementioned 17.9 specification, that is, all proper names are to be spelled with a capital first letter, the balance of each spelled with lowercase letters. Due to the UK, Canada, and the US being bankrupt countries, yes, all these countries have been bankrupt for some time now. They all have currencies that are known as fiat currency. In other words, all our money is worthless. There is no big gold or silver reserve to back it up. Look on any UK banknote and you will see the words, "I promise to pay the bearer." It is a promissory note, an open-ended, blank endorsed security, nothing more, worthless basically. Stay with me. This will make sense soon enough. Grammar, punctuation, and capitalization. The National Aeronautics and Space Administration, known as NASA, the father of all lies, one of the largest film production studios in the world. They absorb more alleged tax dollars than any other organization in the world. And I hate to tell it to you, but your mythical moon landing was filmed right there at NASA's film production studio. Has published one of the most concise U.S. government resources on capitalization. NASA publication SP-7084, Grammar, Punctuation, and Capitalization, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia. At Chapter 4, Capitalization, they state, Noun 4.1, Introduction. First, we should define terms used when discussing capitalization. All caps means that every letter in an expression is capitalized like this. Caps and LC means that the principal words of an expression are capitalized like this. Caps and small caps refers to a particular font of type containing small capital letters instead of lowercase letters. Elements in a document, such as headings, titles, and captions, may be capitalized in either sentence style or heading style. Sentence style calls for capitalization for the first letter and proper nouns, of course. Headline styles calls for capitalization of all principal words, also called caps and LC. Here we see that in headlines, titles, captions, and in sentences, there is no authorized use of all caps. At 4.4.1, capitalization with acronyms, we find the first authoritative use for all caps. Acronyms are always formed with capital letters. Acronyms are often coined for a particular program or study and therefore require definition. The letters of the acronym are not capitalized in the definition unless the acronym stands for a proper name. Wrong. The best electronic publishing system combined, what you see is what you get. WYSIWYG features. That's the wrong way to exhibit that under the law of grammar. Okay? The correct method. The best electronic publishing system combined, what you see is what you get. WYSIWYG features. This cites, by example, that using all caps is allowable in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard, so that definition is required. Could this apply to a lawful proper Christian name? If that were true, the John Smith would have to follow a definition of some sort, which it does not. For example, only if John Smith were defined as John O'Reilly, Holistic Nutrition of the Smith Medical Institution, to Holistic John Smith would this apply. The most significant section appears at 4.5, Administrative Names. Officials, designations of political divisions, and of other organized bodies are capitalized. Names of political divisions: Canada, New York State, United States, Northwest Territories, Virgin Islands, Ontario Province. Names of governmental units: U.S. Government Executive Department, U.S. Congress, U.S. Army, U.S. Navy. According to this official U.S. government publication, the states are never to be spelled in all caps, such as New York State. The proper English grammar and legal style is New York State. I'm going to show you here in a minute how what is being articulated here is actually found in the Constitution, the Articles of Confederation. It's even found in the Declaration of Independence, because there is law and rules to grammar. And these people, back in the days, were cognizant of this. Reviews Manual on Usage and Style, the Use of a Legal Fiction, the Real-Life Dictionary of Law. So we're quoting the source, telling you guys where it's all being found. I've added a lot to this document. Like I said before, it was only like 10 pages. It's up to 25 now. And I'm going to continue to show you over and over and over. I don't care how they splice it, how they dice it, how they look at it. I'm even showing you in their own fucking bullshit Black's Law dictionaries where they're agreeing with this. All right? Reviews Manual on Usage and Style, the Use of a Legal Fiction, the Real-Life Dictionary of the Law. The author of the Real-Life Dictionary of the Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction, noun, a presumption. Pay attention to this. A presumption of fact assumed. A presumption of fact assumed. This is a perpetual conflict of interest right here. How can it be presumed and assumed to be a fact? Or that it is a fact that is presumed and assumed? It's either a fact or it's not a fucking fact. There's no presumption and assumption in fact. It's either true, correct, accurate, not misleading, or it's not. But in their spiritual legal battle between lawful and legal, they're allowed to use presumptions and assumptions. Because remember, no fact or law will be tried in a court. The plaintiff is presumed and assumed to have filed accurate, not misleading pleadings. And so it's incumbent upon the defendant to prove their innocence instead of innocent until proven guilty, because in their courts, under Article 1, Section 8, Clause 9, and Article 4 venues, the accused is guilty until proven otherwise. So legal fiction, a presumption of fact assumed by a court for convenience. Well, isn't that convenience to deprive you of your life, liberty, pursuit of happiness, and enjoyment of property under a farce, absent a victim, absent a crime, absent verified pleadings, without following the structural law of grammar and style? Isn't that fucking convenient? Consistency, or to achieve justice. There is an old adage, fiction arises from the law and not the law from fiction. This is very true. It's not an old adage. It's actually a maxim of law. From the law, fiction arises, and from fiction, no law is created. So when we are registered at birth, the government produces a corporation, all right, that birth registration, okay? The birth registration is the title to presumably your precious value time commodity, future labor. It's being pledged, all right, your mother being the informant, and they go ahead and probate an estate for you, because they can't just blatantly steal from you. This is why I laugh at these attorneys out there that say, there's no secret estate, there's no secret trust, there's no trust funds. The fuck if there's not. Because if there wasn't, these people would be swinging from fucking trees. So when we are registered at birth, all right, your given name is given to them, and they create the birth estate through the state register, which is a chief probate officer, who then disseminates certificates of title, birth certificates, bills of lading, warehouse receipts, to the Treasury of the United States, the state treasury, the county recorder's office also has an account. The government produces a corporation, all right? Whether it's a registered or unregistered corporation doesn't fucking matter, because if you read Title 26, it's pretty clear. Registered or unregistered corporations are still subject to Title 26. This is how they're getting people stuck with failure to file, failure to register, tax liability and stuff, because they're presuming and assuming that you are cognitive of the fact that you are operating a United States domestic trust, a United States citizen that is a United States debtor, a United States vessel for which they created by way of the informant providing them the information. All right? A straw man by placing our name in all capitals. But why, you ask? Well, as we are a bankrupt country just waiting to go into economic fold, exactly what is about to happen in the U.S., the government, we're in a period of liquidation right now. See, before they used to go under reorganization, but you can only reorganize so many times before you have to fucking liquidate. All right? So they're in liquidation. In my humblest belief, they're in liquidation. And that's why you're seeing a drastic change. You're seeing the National Guard on the streets during elections in Washington, D.C. and stuff, because I don't think they're able to reorganize anymore or reconstruct anymore. I think they're in time of liquidation. The government needs collateral to invest and to receive loans on. So we, the people, become slaves in bondage to be used as collateral with lenders. Now, this statement is not conjecture. This is validated and verified in the 73rd Congress, First Session, Volume 77, Part 1. It is articulated over and over and over and over again in 1,156 or 58 pages of the 73rd Congress, First Session, Volume 77, Part 1. That the people and the people's assets are hereby mortgaged. Mortgage is another word for trust. It's just a fancy word for trust. The Congress hereby pledges all the assets, every blade of grass, your precious value time commodity, your life source energy, your biological products and offspring, for the benefit of the United States, so they can do international business. This is what makes you the accredited investor in the United States. This is what makes you a preferred stockholder in every business registered with the Secretary of State's office, because they are all insolvent, financially bankrupt. It's your precious value, time, commodity, and life source energy that has value, monetary value, if you will. Debt is money. Money is debt. The new law coining and defining what money is was defined in the 73rd Congress, First Session, Volume 77, Part 1, where it defined the new money, notes, drafts, bills of exchange, bankers, acceptance, trade acceptances, contracts, will be lent to the banks. Banks aren't lenders. They're pawnbrokers. They're dealers, transfer agents, securities intermediaries. Ladies and gentlemen, you're the bank. You're what's floating everything. And these sinister, cynical fucking pricks sitting on the bench know this shit. A great majority of them do. And if they don't, they shouldn't be sitting on the fucking bench. If they don't know that, they shouldn't be sitting where they're sitting. Some of them might have plausible deniability and not actually know that. And that's a travesty. Orrin's Dictionary of Law. From Orrin's Dictionary of Law, published by the West Group, 1999, within the definition of fiction is found: a legal fiction is an assumption that something that is or may be false or non-existent is true or real. What a just system you have. We're just going to live in Never Never Land. We're going to pretend there's fucking food on the table, Peter. And as long as the fucking ignorant populace that's illiterate doesn't know any better, and we can keep them in our public fool system, we'll be able to generate mass amounts of wealth for which we will carry no liability. We'll have no skin in the game. We risk losing nothing. And we stand to gain everything under this artifice and scheme. Legal fictions are assumed or invented to help do justice. Justice for who exactly at this point? Seems like that'd be the work of the devil if you ask me. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Well, legal title is different from root title. Equitable title, under the doctrine of merger, merging legal and equitable title together, becoming grantee absolute, unspoilated owner, if you will, root title, then there would be no discrepancy with this whole legal title and equitable title thing and the separation, and one being the trustee and one being the beneficiary and one having a right of use and one actually having legal authority over it, or easements and so on and so forth, right? So they create all this subterfuge to separate you from your rights. But they fail to disclose material facts, misrepresented material facts, using artifice and a scheme to do so. Merriam-Webster's Dictionary of Law. Merriam-Webster's Dictionary of Law in 1996 states, legal fictions, something assumed in law to be fact, irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fractions. Fields versus Fairbanks North Star Borough. This is the reason behind the use of the all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real, flesh and blood women and men. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not following their own recognized authorities. In the same respect, by identifying their own government entities in all caps, they are legally stating that it is also intended to be a legal fiction. The use of all caps for writing a proper name is an internal style for what is apparently a predetermined usage and, at this point, unknown jurisdiction. Do not make the mistake of thinking that still does not apply. Do not make the mistake of taking advice from anyone who studies or has studied Orthodox law, as they especially will not know this. They were kept well away from this deliberately. Policy do not, police do not know that us and them are slaves in bondage. Solicitors and lawyers do not know that them and us are slaves in bondage. And most government agents do not know either. So in other words, go through this again so it's not all choppy and blocked up. It's 100 and some odd degrees here with, Lord only knows, probably 90% humidity. It's a hot booger here today. And I'm sitting here in a Carhartt t-shirt or Carhartt sweatshirt. So give me a second here. Do not make the mistake of thinking that this information above being disseminated to you does not still apply. Do not make the mistake of taking advice from anyone who studies or has studied Orthodox law, as they especially will not know this. They were kept well away from this deliberately. Police do not know that us and them, you and I, are slaves in bondage. Solicitors and lawyers do not know that them and us are slaves in bondage, and most government agents do not know either. The main key to legal fiction is assumption, as noted in each definition above, and the conclusion here. There are no official or unofficial English grammar style manuals or references, publications that recognize the use of all caps when writing a proper name. To do so is by fiat, within and out of an undisclosed jurisdiction, by unknown people for unrevealed reasons, by juristic license or arbitrary presumptions not based on fact. The authors of the process unilaterally create legal fictions for their own reasons and set about to get us to take the bait, fall for the deceit. The great thing is, we don't have to participate. It is as easy as being knowledgeable, aware, and then just politely declining their offer to contract. Assumption of a legal fiction. An important issue concerning this entire matter is whether or not a proper name, perverted into an all-caps assemblage of letters, can be substituted for a lawful Christian name, or any proper name, such as the state of Florida. Is the assertion of all capital letters names legal? If so, from where does this practice originate and what enforces it? A legal fiction may be employed when the name of a person is not known and, therefore, using the fictitious name John Doe as an alternative or interim artifice to surmount the absence of the true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. It is an acceptance with no proof. Simply to assume is to pretend. Oren's Dictionary of Law says that the word assume means to take up or take responsibility for, to receive, to undertake. See assumption, to pretend, to accept without proof. These same basic definitions are used nearly all of the modern law dictionaries. It should be noted that there is a difference between the meaning of the second and the third definition with that of the first. Pretending and accepting without proof are the same, without proof are of the same understanding and meaning. However, to take responsibility for and receive or assumption does not have the same meaning. Oren's defines assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the words assume are combined? In a literal and definitive sense, the meaning of assume would be the pretend acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of legal fiction, John P. Jones, in place of a proper name, John Paul Jones, implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproven assumption is made, unless the assumption is proven wrong, it is considered valid. An assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accord with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps, resembling a proper name, but grammatically not a proper name, is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of default thereon? What happens if the proper name, i.e. John Paul Jones, answers for or assumes the fabricated name, i.e. John P. Jones? The two become one and the same. This is the crux of the use of the all caps name by the U.S. government and the states. It is the way that they can bring someone into a de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt. Why won't they use the state of Texas, proper noun, upper lowercase lettering, or John Doe in their courts or on the driver's license? What stops them from doing this? Obviously, there's a reason for using the all caps name, since they are very capable of writing proper names, just as their own official styles manual states. The reason behind legal fiction is found within the definition as cited above. Now, I'm going to prove to you why this is so important. Why I firmly believe that attorney who was in his 70s, 40 years in the field, told me everything you need to defeat the court case, Derek, is on the first document you're ever served. So if that be the charging instrument, allonge to an affidavit sworn to under the pains and penalties of perjury, along with a statement of facts and summons, it ought to be pretty easy to destroy right out the gate with an abatement or demur. And I'm going to show you in the constitutions, and all 50 state constitutions are similar to the language exhibited here. And I want to point out a few words here. Because remember, I told you, it's not just the name that you purportedly use. You don't own it. You purportedly use it, or been known to use something that's similar anyway. It's also in the way that they articulate their entity, their corporate fiction, their de facto structure. But the constitutions all say how prosecution and the style and process is supposed to be handled. So let's look at what the state constitutions have to say about style and process. Now, there's going to be a bunch of attorneys, no doubt, on this video, squawking and talking about this motherfucker don't know fucking shit. I'm going to tell you right now, I put more dicks in the dirt than Carter's got fucking nuts articulating this shit. It's not fucking rocket scientists. And for these people to spend $180,000 to get an education and come out fucking more ignorant than when they went in is absolutely fucking astonishing to me. Under Article 5, Section 24 of the Nebraska State Constitution, all meaning fucking any, motherfuckers, all means any, all prosecution must is authoritative and fucking controlling. It's not may, it's not shall, it's must be carried on in the name of, and just to emphasize it, just so you fucking people didn't lose sight of what they were trying to structure here, they put it in quotation marks for you. The state of Nebraska must be carried on in the name of and the style, the state of Nebraska. When they say style, they're talking about the rules and the law of grammar. If your document doesn't say the state of Nebraska, exactly as how it's articulated here, you are not in a constitutional venue. You are in an administrative venue under a de facto, defunct, bankrupt fucking corporate organization trying to pledge you as surety for benign statute, code, and city ordinance and rule and regulation violations with no victims. So if it says plaintiff, the state of Nebraska, or the people of the state of Nebraska, or whatever it says, and it's in all caps, grammatically incorrect, if you don't make the issue when you see that issue, you waive that motherfucking issue. That's an issue that's brought up on abatement. People go, well, how do you defeat having to plea? Simple. Abatement or demur. Get the ball started right away. He who slumbers on his rights fucking has none. If you don't make the issue timely, you waive the motherfucking issue. Get on the ball. Grab your nuts. Drop your cock. Grab your socks. It's time to fucking rock. Can't sit around and be a pud pounder all fucking day long. Spoon feeding you guys this information. Use it. Use it. Your Honor, does the state constitution take precedence here? Is it the law of land? Is it controlling and authoritative? Of course they're going to say yes. Yes, it is. Are you on your oath today? Absolutely. Great. I bind you to your oath and I accept your oath of office. I bind you there to it. You're going to defend my rights with vigor, even unto death. You understand me? Capiche? You got me, compadre? You're going to protect me like you protect these fucking defunct, bankrupt corporate entities. And you're going to protect my unalienable rights with vigor, even unto death. That means if you got to go out there in the street with a prosecutor and draw down upon him and euthanize him, you will do so to protect my unalienable motherfucking rights. Now we got binding agreement. Judicial notice. Let the record of this court recognize that the judge will defend me even unto death. Well, I don't work for you. The fuck if you don't. If you don't work for me and you're stating that, then you're not operating underneath the Constitution, are you? And further proof of that is the fact that these pleadings being put before the court, the clerk of the court should have never even ledgered or put on record because they're deficient in following the law of the land and the rules and grammatical style and law that has been set forth in the Constitution under Article 5, Section 24, where it says of the Nebraska State Constitution, all prosecution. We don't care if it's criminal, civil. We don't give a shit what it is. Don't care. All prosecution must, mandatory, authoritative, compelling, all right, be carried on in the name of, and it specifically shows you the style. So if that pleading, that summons comes and it's all capital letters, it's grammatically incorrect. And this is why the judge will ask you, can you read English? And you say, yeah. And you say, I'm not subject to your jurisdiction. And they're thinking to themselves, then why the fuck are you here? Because if you can read English, you clearly know that this summons doesn't say shit. You clearly know that the complaint doesn't say anything, that the information filed doesn't say shit, that none of this even pertains to you. We don't actually need you to hypothecate your credit into existence. We don't even need you here. They only drag people into the courtroom to give it some source of visual appearance of legitimacy. They really don't need you. They hypothecate your fucking credit every fucking day. They don't give a fuck about your signature. They don't need your fucking authority. They've usurped authority otherwise not delegated to them through war powers. They've stolen your precious value time commodity and pledged it to the IMF to do international motherfucking business. Let me go on further, just in case you're not catching what I'm laying down, because it's not just about the name. The other thing that I noticed is on the summons and the pleadings, let's just say it's the state of Nebraska versus Derek S. Gonzalez. Well, not all parties have been properly notified. What do you mean? Well, the United States of America needs to be put on notice as a defendant here. Not all real parties in interest have been notified. The United States of America is an interested party as a defendant. Either that or they're the plaintiff working on behalf of the state and with the state. Because the United States is nothing more than a glorified property management company for the United States of America. So that means that the state, the federated state, created this birth ens legis entity, this nom de guerre, this United States domestic trust, this United States debtor, this United States vessel, that the United States of America needs to be duly informed of this prosecution. The Solicitor General of the Treasury needs to be informed, and I need to see the delegation of authority, warrant of attorney, letter of appointment, grant of assignment from the IRS for you to touch the decedent estate fucking property, motherfuckers. Sorry, it's getting a little extreme, a little technical. Most of these judges know this. A few attorneys. Most of these attorneys will tell you that everything I'm telling you is crazy cracker shit. I'm going to tell you right now. They are absolutely either willfully ignorant or they have a wanton disregard for the law. I don't know which it is. Far be it from me to pass judgment on them. But it's one of two fucking things. Which fucking lie is the truth? You're dumber than a sack of shit, or you have a willful wanton disregard for the law and you're unjustly enriching people while fleecing them at a phenomenal rate. Code of Criminal Procedure, Chapter 1, Article 1.23, Dignity of State. And we just went through a whole deal about how these codes and procedures and all that shit is bullshit. Look how they articulate it. Dignity of the state. It says effectively nothing. The style, right here. Look, the style, which is the law of grammar, the style of all means any, writs. What kind of writs we got? We got writ of coram nobis, we got writ of certiorari, we got writ of quo warranto, writ of mandamus, all kinds of ancient writs, right? And in Texas, they're clearly pointing out that the style, the law, the grammatic rules of all writs and process shall be, right here, the state of Texas. All right? Now, this is also articulated in the Constitution for the state of Texas as well. I just happen to find this in the criminal code. All prosecution shall be carried on in the name and by the authority of the state of Texas. See how these quotation marks are here? So when the plaintiff is the state of Texas, it should read in the name and by the authority of the state of Texas, but it never does it? It just says, the state of Texas in all capital letters. They're showing you that they're operating under a federate state, which is a subsidiary corporation of Washington, D.C., District of Columbia, a bankrupt, defunct, not only morally bankrupt, spiritually bankrupt, but also financially fucking incompetent and bankrupt organization. And they're glorified fucking pawnbrokers hypothecating a pledge of your future sweat equity and labor into existence to accumulate credits on account and your good name without your knowledge, under the guise that it's in the name of safety and you somehow caused harm, damage, and loss to their imaginary fucking principle. All prosecution shall be carried on in the name and the authority, and by the authority of the state of Texas, and conclude means that at the end of this statement, whatever's done in the pleadings or whatever, in conclusion, at the end, and conclude against the peace and dignity of the state. I've looked at a lot of Texas cases. I have never seen this language ever in any fucking pleadings, in any fucking summons. I've never seen it in any fucking civil or criminal matter. But isn't it funny that it's here in the criminal procedures chapter where it states specifically the style on all writs and process that must be used? Under Article 6, Section 13 of the Nevada Constitution, all prosecution, all means any, prosecution must again being authoritative, be carried on in the style being the grammatical law and rules of grammar, and name of, right here, the state of Nevada. And it's in quotation marks, trying to emphasize that if it is not exactly like that, it is not a legitimate motherfucking process. It's not a lawful process. It's a legal process. It's an administrative issue. It's an administrative process. There's an unlawful conversion going on here. And one thing false, all things fucking false. Now, what the courts will sometimes do is go, well, we're going to give the prosecution 30 days to amend. Right? Had that happen. 30 days go by, and they'll change the name of the defendant and put it upper or lowercase, being cute, being smug. But at the same time, can one be a name? Where's the law that requires a man to have a name? See, I don't know if you guys caught it the other day. I put up a small video of me in court, which wasn't too awful long ago. Our buddy Steve-O, bench pounder, he's actually a professor, an instructor at a college, an accredited college for law school. And he teaches law. And boy, oh boy, I was just so happy to be there. I even went into his office, put my feet up on the mayor's desk. I was having all kinds of fun in that fucking building. Kid Rock says it ain't cocky if you can fucking back it up. And there's nothing wrong with being the biggest swinging dick in the village if you can back that shit up. And by the time he took the bench, everybody in that fucking pretend court was chattering. Who is that guy? What's going on? Are we being audited? Are we being provoked by the FBI? Is this some kind of sting going on here? Who is this guy coming here with all his fucking confidence? By the end of it, old Steve-O, unbeknownst to him being recorded, because I don't have to let criminals know I'm fucking recording them. You should conduct yourself and govern yourself accordingly at all times, as though you're always being watched. You should always carry yourself with dignity, honor, respect, and integrity. Why would I have to let you know that I'm coming into the people's building in the interest of justice and have to notify you criminal fucking cretins that I'm recording so you'll clean up your fucking act? So you'll find some procedural violation to throw the case because you don't want to deal with it? Or you'll find another way to meticulously put the words together to create some type of joinder and manufacture consent? Or presumed and assumed consent? Get the fuck out of here. Fucking criminals. Criminals. At least when a porn star says, hey, I've been working hard all fucking day, I don't want to be on camera. I understand that. No harm, no foul. No big deal, right? But for criminals, I can't understand it. I've been robbing, looting, plundering, and stealing all day, man. I don't want to be on camera while I'm robbing, looting, and plundering and stealing from you. No cameras in my craft. Fuck out of here. That unrealistic bullshit. And then the way that the propaganda for the news media is all structured about these people are holier than thou, honest integrate, law-abiding people who advocate for your rights. Get the fuck out of here. The incredulous insanity of people being able to say that with a straight face, it just blows my fucking mind. So, under Article 6, Nevada Constitution, Section 13, it tells you the style. Okay? Says it must. Says the style. There's a reason I'm pointing this shit out to you. Use it. Use it in your abatement. Use it in your demur. Under the California State Constitution, all prosecution, there it is again, all prosecution. Let them tell you that they're not operating underneath the Constitution and dragging you into a foreign jurisdiction using foreign law without the express written consent of the Solicitor General of Washington, D.C. Watch how fast their fucking butthole puckers up. Must be carried out in the style and the name of the people of the state of California. I have never seen a case out of California where the summons and the pleadings have been structured in this fashion. And must, not shall, not might, not can, must be conducted in their name and by their authority. Pursuant to Article 5, Section 8 of the Iowa Constitution, all prosecution must be conducted in the name and the authority of, and again, it's in quotation marks, the state of Iowa, specifically and grammatically spelled correctly, and it must be done in the authority, which means the style and law of grammar. The exact language states that all process is styled in the same way. It doesn't matter if it's criminal, civil, private administrative process, whatever. It all must be structured in the same fucking manner. Right? If the constitutions are the law of land, Article 6, Clause 1 and 2, the treaties and debts and contracts and constitutions created before the adoption of this Constitution are just as valid as after the adoption of this Constitution. Well, if that rang true and supreme and that they are the law of the land, then the gig's up, boys. The gig's up, ladies. Point out the clear discrepancies in the names, because before the court can move forward and decide anything, everything must be properly identified by its proper name. Under Idaho Constitution, all criminal prosecution and penal actions must, penal actions being administrative, must be carried on in the style and name of the state of Idaho. It's right there in the constitutions. Let them tell you they're not operating by the Constitution. The Constitution don't mean jack dick. Go to the trunk of your car, say, I need to leave court, go to the trunk of your car, pull out a rope. When you come back into the courtroom, start fashioning it as a noose. When he asks you what you're doing, say, just making a necktie. Sounds to me like you taking your income under false pretense, engaged in insurrection, sedition, mixed war against the Constitution, mixed war against the people. Did you just say you're not honoring your oath today? You're not standing on your oath, and you're not going to honor the Constitution, enforce the Constitution, protect the Constitution, and protect my unalienable rights, motherfucker? Well, then by right, you're engaged in treason, sedition, insurrection, and rebellion. You should be swinging from a light pole. So I'm just in here doing my civic duty, fashioning your necktie. According to Article 6, Section 22 of the Colorado State Constitution, all prosecution must, again, authoritative, controlling, style, which talks about the law of grammar and rule, all prosecution must be carried on in the style and name of the people of the state of Colorado. To this day, not once has anybody come to me from Colorado with a case that I've reviewed where it says the people of the state of Colorado in proper case. Right? And again, I pointed it out to you, Rule 17, plaintiff and defendant capacity are public officers. So if that's how they're operating in the administration side of things, treating you as though you're an employee, demand the I-9. When did I take an oath? When did I join your ranks? And furthermore, why haven't I been compensated? Here's my invoice for all the back pay for operating and taking care of your little fucking ens legis entity, nom de guerre, name of war, decedent estate, with all these constructive trusts and everything else I've been surety for. Here's my bill. Because involuntary servitude, peonage, bondage, and slavery are illegal, and using an artifice and a scheme and a menagerie of language to ensnare people in is criminal. Pursuant to Article 5, Section 15 of the Wyoming Constitution, all prosecution must be carried on in the name and by the authority of the state of Wyoming and must conclude against the peace and dignity of the state of Wyoming. I've never seen anybody's court documentation ever, whether it be the summons, the pleadings, ever using any of this language. Grammatically styled properly. And damn sure never seen it, anybody's summons or information or pleadings state against the peace and dignity of the state of Wyoming. Never seen it. According to the Article 8, Section 16, and Article 24, Section 6 of the Utah Constitution, all prosecution, all, meaning any, prosecution must be carried on in the name and by the authority being the style, law of grammar, of the state of Utah. Under Article 6, Section 25 of the Arizona Constitution, all prosecution must, again, a great dissertation by the late Justice Scalia on statutory reform for the federal governments that he quoted said the states should correct is the fact that federal statutes at the time that he was giving this opinion of correction needed to be made by the legislator said the words shall and may are not authoritative and not an indicative of compelling performance. He said that if the legislator had intent to make something mandatory, the word must should be used in lieu of may or shall. I shall go get a license at some point. I shall take a shit at some point. Does that mean I'm going to do it now? Might do it the day I die. I don't know. Shall, must, and may are all different. Shall and may are not authoritative. Must is definitive. Must is controlling. And Justice Scalia did a nice dissertation on it. I'll find it for you guys and I'll bring it out to you guys. Now, that was addressing federal legislation. State legislation, he made a strong suggestion that if you want things to be authoritative, if you think you have the authority to tell people what to do, your legislation needs to say must, not shall, not might, not may, but must if it's authoritative and it's required if they have the authority or they think they have the authority. Well, they know they don't have the authority to use that fucking language. Only with their agents and agency do they have the authority to do that. Under Article 6, Section 25 of the Arizona Constitution, all prosecutions must be carried on in the style and the name of the state of Arizona, exactly how it is in the quotation marks, and by its authority. All right? Under Article 7, Amendment, Section 19 of the Oregon State Legislature Constitution, all prosecution must, again that word must, be carried on in the name and by the authority of the state of Oregon. Additionally, the section specifies that all indictments must conclude with the phrase against the peace and dignity of the state. Never seen any of that shit. I've seen indictments from a lot of different places, not personally from Oregon. They never have any of this fucking language, ladies and gentlemen. Under Article 4, Section 27 of the Washington Constitution, all prosecution, civil, criminal, doesn't fucking matter, must be conducted in the name and by the authority of the state of Washington. The legalities of the all capital letter names. We could go on for hundreds of pages. By the way, all of this constitutional information right here, this is what I added to this document, along with some other statements that I'll point out later. This can be found in all 50 state constitutions, by the way. You just got to go look. I just did a handful of them just for shits and giggles, okay? To make my valid point. The legality of all capital letters names, we could go on for hundreds of pages citing the legal basis behind the creation and use of all capital letter names. In a nutshell, fabricated legal persons, such as State of Texas, all capital letters, can be used to fabricate additional legal persons, fictions arising from the law, not the law from fictions. Bastard legal persons originated from any judicial governmental actor that wishes to create them, regardless of whether he, she, it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation states, all of which are artificial corporate entities since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nations, states of that treaty. Representatives of the people in each nation, state agreed upon and signed it. The federal government is not only created by it, but is also bound to operate within the guidelines of the constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created according to the lawful process or created outside of lawful process? Executive order and directives. For years, many have researched the lawful basis for creating the all-caps juristic person and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all: executive orders and directives. There are color of law, color of authority, color of office without being valid. Law of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative code, rules, and procedures, not due process. So Administrative Procedures Act versus the Fifth Amendment, the Fourth Amendment, and the Sixth Amendment, right? Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln established executive orders 85 years after the independence of the United States. 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned sine die, or without delay. This meant that there was no lawful quorum to set a specific day and time to reconvene, which, according to the Roberts Rules of Orders, dissolved Congress. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the state. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority or lawful due process of the Constitution. Solely in his capacity as Commander-in-Chief of the U.S. military, Lincoln called Congress into session under the authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction based on nothing more meritorious than, so what are you going to do about it? Having a monopoly on the currency, law, and what passes for government and most of the world's firepower, the motto of the powers that be is, we've got what it takes to take what you got. Legal fiction laws such as the Reconstruction Acts and the implementation of the Lieber Code were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. Every purported act in effect today is de facto, based on the colorable fictitious entities created arbitrarily out of nothing without verification, lawful foundation, or lawful due process. All such laws are not law, but rules of rulership by force conquest originating from and existing in military martial law jurisdiction. Military martial law jurisdiction, jurisdiction of war, win-loss, interactions consisting of eating or being eaten, living or dying, food chain, law of necessity, suspension of all law other than complete freedom to act in any manner, to eat, kill, or destroy or avoid being eaten, killed, or destroyed. No law, lawlessness, complete absence of the law, basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity. No lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence. No bona fide enforceable contract, no valid enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demands from self-admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone, Every president of the United States since Lincoln has functioned by executive order and executive fiat issued from the military martial law jurisdiction, with the only law being the law of necessity or the law of the jungle, i.e. the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win-lose games, otherwise known as wagering. All existing authority in the United States today derives exclusively from the war powers. Truman reaffirmation of operational authority under the war powers begins. Now, therefore, I, Harry S. Truman, President of the United States of America, acting under and by virtue of the authority vested in me by Section 5B of the Trading with the Enemy Act of October 6, 1917, 40 Stat 415, as amended, Section 5B of Appendix of Title 50, and Section 4 of the Act of March 9, 1933, 48 Statute Large 2, Sic Transit Rights, Substance, Truth, Justice, Peace, and Freedom in America, the land of the free and the home of the slave, the brave. The abolition of the English and American common law. Here's an interesting quote from the 1973 sessions of the U.S. Supreme Court. The American law in this country, the law in effect in all but a few states until the mid-19th century, was a pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe v. Wade, 410 U.S. 113. Roe v. Wade was obviously overturned, ladies and gentlemen. In effect, Lincoln's second executive order abolishes the recognized English common law in America and replaced it with laws based on a fictional legal foundation, i.e. executive orders and directives executed under authority of the war powers. In America, in April of 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, and codes based on executive orders and not the due process specified within the organic Constitution. Existing and functioning under the law of the necessity ab initio, they are all non-law and cannot validly assert jurisdiction, authority, or demand for the compliance from anyone. They are entirely rules of rulership, i.e. organized piracy, privateering, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanisms to accomplish any result other than disruption, conflict, damage, and devastation. The established maximum of law applies. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. Emphasis added. Exception from punishment, penalty of harm. Everybody says, well, if we're doing what you're saying, Derek, what would happen if somebody murdered somebody or sodomized somebody? Well, obviously there's an aggrieved party. There's a special venue for that. There's proper jurisdiction and venue for men and women aggrieved to get resolution for prosecution to be had. What I'm talking about is the degenerate fuckbags that are engaged in piracy, creating taxation without representation, presuming and assuming we're all bound to their legislative edicts, which is staunchly forbidden under Article 1, Section 10, Bills of Attainder. Using artifices and schemes to ensnare everybody and cut us out of our rights, titles, and interests, dividends and derivatives, futures and annuities that are due and owing to each and every one of us, because we are the accredited investor in the United States. Therefore, we're the big swinging dick in the valley. We're the boss. So yeah, you can fire that cop on the side of the road. He has no business even fucking talking to you. Absent a victim, absent a crime, reasonable articulable facts supported by reasonable articulable suspicion and probable cause that you're about to commit a crime, actively engaged in a crime, or disturbing the peace, they should leave you the fuck alone. Applying it all to current laws. An established maximum of law states the importance of the name. In order rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Title 3, Pleadings and Motions, Rule 9a, Capacity. Federal Rule Civil Procedure states in pertinent part, When an issue is raised as to the legal existence of a named party or party's capacity to be sued, or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment. Remember I was telling you guys, negative averments, affirmative defenses, averments, interrogatories, request for admission, subpoena ducis tecum, subpoenas, and depositions, supported by affidavit, all right, which shall include supporting particulars, right? Supporting particulars. I just went through like 7 or 8 different discovery tools you have. Go back and listen to the video. I'm not going to repeat them, all right? Supporting particulars. You want to get in the exclusive jurisdiction of equity? You'd probably do a bill in equity and include a bill of particulars, right? Now, when they're bringing alleged allegations, it states in the Special Supplemental Rules for Maritime Admiralty adopted July 1st, 1966, that if the defendant, if the plaintiff's pleadings are not specific enough that grants rise to the defendant asking for a bill of particulars or a more definite statement, the plaintiff is supposed to withdraw their information or complaint. They never do. They double down. They're wagering. At this juncture, it is clear that the existence of a name written with all caps is a necessity-created legal fiction. This is surely an issue to be raised, and the supporting particulars are outlined within this memorandum. Use of the proper name must be insisted upon as a matter of abatement, correction for all parties of an action of purported law. However, the current courts cannot correct this, since they are all based on presumed assumed fictional law and must use artificial juristic names. Instead, they accept the lawful Christian man or woman to accept the all caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed, and a worldwide plunder enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honest, productive labors, the way those upon whom they parasitically feed are forced to conduct their lives. Oklahoma statute, since the entire game fiction functions on the basis of people's failure to properly rebut a rebuttable presumption, the issue then becomes how to properly rebut their presumptions that you are knowingly and intentionally and voluntarily agreeing to be treated as if you were the all caps name. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma Statute, Chapter 22, 403. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceeding his true name is discovered, it must be inserted into the subsequent proceeding, referring to the fact of his being charged by the name mentioned in the indictment or information. Again, information only applies to agents and agency under Rule 17, plaintiff and defendant capacities, public officer. Complaint is no bueno either. That only applies to entities and agents and agency under the law of agency. What you're looking for is a claim, a man or woman aggrieved making a claim. American jurisprudence. In general, it is essential to identify parties to court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how? If not properly identified, all corresponding judgments are void, as outlined in Volume 46, American Jurisprudence 2D at Judgments. Subsection 100, Parties. A judgment should identify the parties for and against whom it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as a void for uncertainty. Such identification may be achieved by naming the persons for and against whom the judgment is rendered. Technical deficiencies in the naming of the person for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of that party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnotes, numbers, and cites are omitted. The present situation in America, situation in America, a legal person equals a legal fiction. One of the terms used predominantly by the present civil government and courts in America is legal person. Just what is a legal person? Some definitions are a legal person, a body or of persons or an entity as a corporation considered as having many of the rights and responsibilities of a natural person and especially the capacity to sue and be sued, Merriam-Webster's Dictionary of Law, 1996. Person, a human being, a natural person, a corporation, an artificial person. Corporations are treated as persons in many legal situations. Also, the word person includes corporations in most definitions in this dictionary. Any other being entitled to sue as a legal entity, a government, an association, a group of trustees. The plural of a person is persons, not people. See that word, Oren's Dictionary of Law, West Group, 1999. Now, dissimilar things should not be joined and similar is not same. So when they define the term person, meaning a place, a corporation, an entity, LLC, S-Corp, comprehend that doesn't apply to the natural person, which is still a fictitious entity. It doesn't apply to the man. Even a natural person is a fiction. A natural person is still a fiction. If God created man and God has the authority and he's the author and he named what he created man, then fucking man is man. And the contrived legislative edicts that say otherwise are moot. The legislative branch didn't create you guys. They can play with the fiction all they fucking want. God dubbed and deemed you man, being plural. Men and women alike. It's not a sexist comment. Person, an entity with legal right and existence, including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in the court either by themselves or by a lawyer, and generally other powers incidental to the full expression of the entity in law. Individuals are persons. See that? Individuals are persons. So a trust can be an individual. A limited liability company can be an individual. S-Corp can be an individual, ladies and gentlemen, because it's persons, all right? Dissimilar things should not be joined, similar is not same. Persons and man are different. They're fictions of law. In law, unless they are minors or under some kind of other incapacity, such as a court finding them mentally incapacitated, all right? When the court determines that you're mentally non-cop mentis, that's not a medical determination. That's a legal determination. What's the difference? To be legally incompetent means that you don't understand their laws. You're an idiota. You're not subject to their shit because you can't understand their shit because you don't speak their fucking legalese and language. So when a court is declaring and decreeing and the judge is declaring and decreeing that the court decrees the defendant incompetent and non-com mentis, it's not making a medical determination. They're making a legal determination on legal competency. And if the court ever, in its infinite wisdom, declares and decrees you non-com mentis or legally incompetent, you immediately accept the finding of the court and say, have a good day, fuckers, I'm out. Because the second the court decrees that the defendant is legally incompetent, an idiota, non-com mentis, the court lost jurisdiction. And from that point on, whatever they fucking do doesn't matter. Now, if you're dumb enough to stick around in the room after they declare and decree that shit and not leave and fall subject back to the jurisdiction again through their artifice and schemes and casting of spells like a dipshit, And they say, well, we're going to appoint you an attorney because the court just deemed you non-competent. The defendant is non-competent, so we're going to appoint an attorney. Fuck you. You don't have the authority to appoint an attorney because the second the court deemed and dubbed the fucking defendant non-cob mentis, not mentally competent, legally speaking, not medically speaking, the court lost jurisdiction. You don't have the authority to appoint fucking counsel to the defendant. Fuck off. Have a nice day. And if you do think you have the authority, do it and see what happens to you. Many laws give certain powers to persons, which in almost all instances include business organizations that have been formally registered, such as partnerships, corporations, and associations. Duheim's Law Dictionary. Person, noun, person. Latin, persona. Said to be... Oh, I'm being warned by Facebook. Was I using language that was not conducive for your guys' ears? Did you perceive it to be profane and with ill intent, the language that I speak? Well, if you're offended by it, it's only a direct reflection of your projection of what's in your mind. If I say words and they offend you, it's only the perversion within your mind that you're projecting upon me, because you have to still prove my intent when I say those things. And if you can't prove my intent, you're fucked. So if I say go fuck yourself, and you literally think that I mean go fuck yourself, and you're envisioning how you're going to do it, that's a direct reflection on how you preview things, and a direct reflection of your thought process, and has nothing to do with what I said. Kind of like the first time an Australian told me I was a randy cunt, and I was like, wow, boy, the perversion of my own mind led me to believe that he was cussing me and calling me something derogatory. And then later on, he's like, no, randy cunt means good friend. And my mother goes, I don't ever want to hear that come across in this house again. I never want to hear that word again. She was mortified. What did she call you? She called me a randy cunt. Anyway. So, Facebook, fuck off. You can take that literally and figuratively. Many laws give certain power to persons, which in almost all instances include business organizations that have been formally registered, such as partnerships, corporations, or associations. But don't forget this. There's also the unregistered, unincorporated businesses. All right? Person, noun, Latin person, said to be compounded of per, through, or by the sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. Commerce allows you to put on a persona, a mask, to do what would otherwise be immoral, what would otherwise cause or shock your conscience. You ever heard the term, I was just doing my job? That's what putting on a title of nobility and a persona does to people, and a costume. Yeah, I might have violated your rights, but according to my policy, I was just doing my job. Does your policy trump the law, motherfucker? People have lost their life for less. Their dicks have been put in the dirt for less. You might want to go talk to your fucking management and say, hey, look, I don't want my dick put in the dirt. And this guy purportedly told me he's going to plant daisy seeds in my ass and water me twice a month. I really don't. If your policy requires that I violate this guy's rights, I don't really want to be pushing daisies out my asshole. And he seems pretty fucking serious about putting my dick in the dirt and planting fucking wildflowers in my butthole. I don't want that, right? The policy doesn't trump law. A lot of these fuckers operate under policy, try to convince you that their policy, somehow you're subject to it, and they're treating you as an agent and agency, and you're not. You're not. A corporation incorporated under the de jure law, i.e. by bona fide express contract between real beings capable of contracting, is a legal fact. Using the juristic artifice of presumption or assumption, a device known as a legal fiction, implied contract, constructive trust. Constructive trusts are always used mainly for fraudulent purposes. Another entirely separate entity can be created using the name of a bona fide corporate legal fact. The name of the corporation by altering the name of the corporation into some other corrupted format, such as the all caps letter or abbreviated words in the name. The corporation exists in law, but has arbitrarily been assigned another name. No such corporation legal fact, nor any valid law, nor even a valid legal fiction can be created under the law of necessity, under no law. Likewise, the arbitrary use of the legal fiction artifice of right of presumption over unwary, uninformed, and usually blindly trusting people can be legitimately exercised under no law. Anything whatsoever done under alleged authority or naked criminal aggression, i.e. law of necessity, can be rendered legitimate. Maximum of law described necessity include: necessity has no law. In time of war, laws are silent. No existent law, the legal condition that universally prevails in the official system of the world today, means that no lawful basis exists upon which anything can be created or be made to transpire, upon which basis allegiance and obedience can be legitimately demanded. Acting under the law of necessity, i.e. lawlessness, allows complete and total right of everyone to disregard any and all alleged assertions of any lawful, verifiable, and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such no non-law is self-confessing to be a naked criminal aggressor and con man who has forfeited all credibility and right to demand allegiance, obedience, or compliance with any jurisdiction he might assert. If you, as a real being, are in real law, and it is impossible for an attorney or judge to recognize or access it, you are not and cannot be made subject to by them in their jurisdiction. The crucial issue is then how to notice them of your position and standing. A person created under the de jure law, with the person's identifying name appearing as prescribed by law and according to the rules of English grammar, is a legal fact. A corrupted alter ego version of that name, manufactured under the legal fiction of right of presumption, will have credibility only so long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it. Legal or lawful. It is crucial to define the difference between legal and lawful. The generic constitution references genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meaning? The following is quoted from a dictionary of law of 1893. Lawful, in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful properly implies a thing conformable to or enjoyed by law. Legal, a thing in the form of or after the manner of law or binding by law. A writ or warrant issuing from any court under color of law is a legal process, however defective. See legal, bold emphasis added. Legal, Latin legalis, pertaining to the understanding, the exposition, the administration, the science, and the practice of law. As the legal profession, legal advice, legal blanks, newspaper, implied or imputed in law, opposed to actual legal, looks more to the letter, form, appearance, and lawful to the spirit, substance, content of the law. Legal is more appropriate for conformity to positive rules of law. Lawful for accord with ethical principles. Legal imports rather that the forms, appearance of the law are observed, that the proceedings is correct in method, that rules prescribed by have been obeyed. Lawful, that the right is act full in substance, that moral quality is secured. Legal is the antithesis of equitable and the equivalent of constructive. 2 Abbott's Law, Dictionary 24. Legal matters administrate, conform to, and follow rules. They are equitable in nature and are implied, presumed, rather than actual express. A legal process can be defective in law. This accords with the previous discussion of legal fictions and color of law, color of authority, color of office to be legal, and a matter does not have to follow the law. Instead, it conforms to and follows the rules or form of law. This is why the federal and state rules of civil procedure and criminal procedure are cited in every court petition so as to conform to legal requirements of the specific juristic persons named, ergo state of Georgia or the U.S. federal government that rule the courts. Lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the organic Constitution has no bearing or authority in the present-day legal courts. It is impossible for anyone in authority today to access or even take cognizance of true law, since authority is law, the law of necessity. Title 12, United States Code 95, which is actually 40 Statute at Large 411, which is the Trading with the Enemy Act of October 6, 1917, that was amended to give the president broad sweeping power in time of national emergency. So the Trading with the Enemy Act is your new trust indenture, ladies and gentlemen. Therefore, it would appear that the meaning of a word legal is color of law, a term which Black's Law Dictionary, 5th edition, page 241, defines as color of law, the appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law and made possible only because wrongdoers is clothed with authority of state, is action taken under color of law, color of office, and color of authority. Executive order rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevail instead of actual law. This takes place on a federal as well as a state level. Government administrates what it has created through its own purported laws, which are not lawful but merely legal. They are arbitrary constructs existing only because the actions of the people acting on fictions, self-created authority, i.e. no authority at all. They are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Looking at the United States Census Bureau, Census 2000 reveals that a legal authority for this census comes from Office of Management and Budget under the Spending Clause. Office of Management and Budget. OMB approval number 0607-0856. The OMB is a part of the Executive Office of the President of the United States. Obviously, Census 2000 is authorized, carried out, controlled, enforced, and implemented by the President, the executive branch of the federal government, functioning as it has been since 1861 in the lawless realm of necessity, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive orders of the president controls the entire nation through various departments and agencies affecting justice, communications, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more, through a myriad of executive orders, proclamations, policies, and decisions. You will find that in the Trading with the Enemy Act, 40 Statute at Large, 411, Section 7E, ladies and gentlemen. That is your saving grace, by the way, full acquittance and discharge under any rule, regulation, executive order, policy, procedure, or proclamation made by the President and Commander-in-Chief of the United States. Every U.S. president since Lincoln has claimed his authority for these executive orders. On Article 2, Section 2 of the U.S. Constitution, the President shall be Commander-in-Chief in the Army and Navy of the United States and of the militia of the several states. When called into actual service of the United States, he shall have power and by and with the advice and in the consent of the Senate to make treaties, provide 2/3 of the senators present concur. He shall nominate and by and with the advice of the consent of the Senate shall appoint ambassadors, other public ministers and councils, judges and of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of the department. In reality, the Congress is completely bypassed, since the Senate was convened in April 1861 by Presidential Executive Order Number 2, not by lawful constitutional due process. There is no United States Congress. The current Senate and House are, like everything, colorable. color of Senate, color of law, color of authority, color of office, under the direct authority of the executive office of the president. The president legally needs neither the consent nor a vote from the Senate, simply because the Senate's legal authority to meet exists only by executive order. Ambassadors, public ministers, consuls, federal judges, and all officers of the United States are appointed by and under authority of the executive office of the president. The Federal Registry is an executive function. The first official act of every incoming president is to reaffirm the war powers. He must do so, or he is devoid of power to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917, and the Amendatory Act of March 9, 1933, the Banking Relief Act. In the Amendatory Act, every citizen of the United States was made an enemy of the government, i.e. the Federal Reserve, IMF, et.al., creditors in bankruptcy who have conquered the country by their greater paper money banking swindle. For the past 65 years, every presidential executive order has become purported law simply by its publication in the Federal Register, which is operated by the Office of the Federal Register, OFR. In 1935, the OFR was established by the Federal Register Act. The purported authority for the OFR is founded within the United States Code, Title 44, Chapter 15, subsection 1506, Administrative Committee of the Federal Register, Establishment and Composition, Power, and Duties. The Administrative Committee of the Federal Register shall consist of the Archivist of the United States or acting Archivist, who shall be Chairman and Officer of the Department of Justice, designated by the Attorney General, and a Public Printer or acting Public Printer. The Director of the Federal Register shall act as Secretary of the Committee. The Committee shall prescribe, within the approval of the President, regulations for carrying out this chapter. Notice that the entire Administrative Committee of the Federal Register is comprised of officers of the federal government. Who appoints all federal officers? The President does. The Act also gives the President the authority to decree all of the regulations to carry out the Act. By this monopoly, the executive establishes, control, regulates, and enforces the federal government without need for any approval from the Senate or anyone else other than his undisclosed superiors. He operates without any accountability to the people at all. How can this be considered lawful? In 1917, President Woodrow Wilson couldn't persuade Congress to agree with his desire to arm the United States vessels traveling hostile German waters before the United States entered World War I. So Wilson simply invoked the policy through the presidential executive order. President Franklin Delano Roosevelt issued executive order number 9066 in December 1941, forcing 100,000 Americans of Japanese descent to be rounded up and placed into concentration camps while all their property was confiscated. Is it any wonder that the Congress, which the president legally controls, did not impeach President William Jefferson Clinton when the evidence for impeachment was overwhelming? On that note, why is it that attorney presidents have used executive orders the most? Who but an attorney would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful, since the entirety of their authority, which is ethically and existently specious, derives from the war powers. I think I was supposed to say suspicious. How debt is assumed by legal fictions. We now refer back to the matter of assumption, as already discussed, with its relationship to arbitrary created juristic persons, ergo the state of California or John P. Jones. Since an assumption by definition implies debt, what debt does a legal fiction assume? Now that we have explored the legal executive basis of the current federal and state governments, it's time to put all this together. The government use of the all caps in place of the proper name is absolutely no mistake. It signifies an internal legal rule and authority. Its foundation is pure artifice, and the results have compounded into more deceit in the form of created, promulgated, instituted, administered, and enforced rules, codes, statutes, and policies, i.e., the laws that appear to be but are not, never were, and never can be. He who enjoys the benefit ought to also bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is subject to its condition or conditions. Bouvier's Maxims of Law, 1856. The birth certificate. Since the early 1960s, state governments themselves specifically created juristic corporate persons signified by all caps have issued birth certificates to persons with legal fictions all caps names. This is not a lawful record of your physical birth, but rather the birth of the juristic all caps name, person, juristic person. It may appear to be your true name, but since no proper name is ever written in all caps, either lawfully or grammatically, it does not identify who you are. The birth certificate is a government self-created document of title for its new property, i.e. the deed to the juristic name, artificial person whose all caps name mirrors your true name. The birth certificate brings the new all caps name into colorable Admiralty maritime law the same way a ship and a ship of state is birthed. One important area to address before going any further is the governmental use of older data storage from the 1950s until the early 1980s as a leftover from various teletype-oriented system. Many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as the early 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps when this technology was first being used and implemented into the mainstream of communications, some legal experts saw it as a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during that same time period, and the birth certificates and other important documents, such as the driver's license, were produced with typewriters, it's very doubtful that this possesses much of an excuse to explain all caps usage for proper names. The only reasonable usage of the older data bank all caps storage system would have been for addressing envelopes or certain forms in bulk, including payment checks, which the governments did frequently. For the past 50 years, there is no excuse that the government computers will not accommodate the use of the lowercase letters unless the older data is still stored in its original form, i.e. all caps, and has not been translated due to the cost of re-entry. But this does not excuse the entry of new data, only legacy data. In fact, on many government forms today, proper names are in all caps, while other areas of the same computer-produced documents are in both upper and lower case. One can only conclude that now, more than ever, the use of the all caps is substitution. The writing of a proper name is no mistake. When a child is born, the hospital sends the original, not a copy, of the record of live birth to a State Bureau of Vital Statistics, sometimes called the Department of Health and Human Rehabilitation Services, HRS. Each state is required to supply the United States with a birth, death, and health statistic. A state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted alter ego all caps version of the baby's true name, i.e. James Wilbur Smith. Certificate noun, Middle English, certificate from Middle French, from medieval Latin, from late Latin, neuter of certificatus, past participle of certificare, to certify, 15th century, a document evidencing ownership or debt, Merriam-Webster's Dictionary, 1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the Executive Office, specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all caps name was merely noted in a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all caps legal person named thereon has become a surety or guarantor, a condition of an obligation that is automatically and unwittingly assumed unless you rebut the presumption by effectively noticing them. It ain't me. Registered security bond, Merriam-Webster's Dictionary, of Law 1996 security something as a mortgage or collateral that is provided to make certain the fulfillment of obligations. Example, used his property as security for a loan. Surety, evidence of indebtedness, ownership, or right to ownership. IBID. Bond, a usually formal written agreement by which a person undertakes to perform a certain act, as fulfill the obligation of the contract, with the condition that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by the person or surety. One who acts as surety, an interest-bearing document giving evidence of a debt issued by a government body or corporation that is sometimes secured by a lien on property and is often designed to take care of a particular financial need. Surety, the person who has pledged him or herself to pay back money or perform a certain action in the principal if the principal to a contract fails, as collateral and as part of the original contract. Duheim's Law Dictionary. A formal engagement as a pledge given for the fulfillment of an undertaking. One who promises to answer for a debt or default of another. Under the Uniform Commercial Code, however, a surety includes a guarantor, and the two terms are generally interchangeable. Merriam-Webster's Dictionary of Law, 1996. Guarantor, a person who pledges collateral for the contract of another, but separately as part of an independently contract with the obligee of the original contract. Duheim's Law Dictionary. It is not difficult to see that the state-created birth certificate with an all-caps name is a document evidencing debt the moment it is issued. Once a state has registered a birth document with the Department of Commerce, the department notifies the Treasury Department, which takes out a loan from the Federal Reserve. The Treasury uses the loan to purchase a bond. The Fed holds a purchase money security interest in the bond from the Department of Commerce, which invests the sales proceeds in the stock or bond market. The Treasury Department then issues Treasury securities in the form of Treasury bonds, notes, bills, using the bonds as surety for the new securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate. This also means that the bankrupt corporate U.S. can guarantee to the purchaser of their securities the lifetime labor and tax revenues of every citizen of the United States, American, with a birth certificate as collateral for the payment. This device is initiated simply by converting the lawful true name of the child into a legal juristic name of a person. Title 26, United States Code 163, H3B2, disallowance of deduction for personal interest, qualified resident interest, acquisition indebtedness, and $1 million limitation. The principal part of everything is in the beginning. Legally, you are considered to be a slave or indentured servant to the various federal, state, and local governments via your state-issued and state-created birth certificate in the name of your all-caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when one voluntarily obtains a driver's license or Social Security account number. The state even owns your personal and private life through your state-issued marriage license certificate issued in the all-caps name. You have no right in birth, marriage, or even death. The state holds title to all legal persons the state creates via birth certificates until the rightful owner, i.e. you, reclaims, redeems it by becoming the holder in due course of the instrument. The main problem is that the mother and father, and then the 18-year-old man or woman, voluntarily agreed to this contrived system of plunder and slavery by remaining silent. A legal default latches, and failing to claim one's own right, the maximum of law becomes crucially operative. He who fails to assert his rights has none. The legal rules and codes enforce themselves. There is no court hearing to determine if those rules are correct. Government rules are self-regulating and self-supporting. Once set into motion, such laws automatically come into effect, provided the legal process has been followed. The various bankruptcies. The corporate legal person, known as the United States, is bankrupt and holds no lawful constitutionally mandated silver or gold coin or bullion, with which to back any currency. All privately held federal all private held and federally held gold coins and bullion in America was seized via executive order of April 5th, 1933, and paid to the creditors, the private Federal Reserve Corporation, under the terms of the bankruptcy. Congress, still convening strictly under executive order authority, confirmed the bankruptcy through joint resolution to suspend the gold standard and abrogate the gold clause, June 5th, 1933. House Joint Resolution 192, June 5th, 1933, which this is going to be 48 Statute at Large 112, because the House Joint Resolution was an internal resolution, and 48 Statute at Large 112 is the statute at large that is verbatim House Joint Resolution 192. 73rd Congress, First Session, Public Law 7310. This 1933 public law states in part, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in any amount in money of the United States measured thereby, is declared to be against public policy. They're all operating under public policy. The corporate U.S. Declared bankruptcy a second time, whereby the Secretary of Treasury was appointed receiver for the bankrupt U.S. in Reorganization Plan Number 26, Title 5, United States Code 903, Public Law 94, 564, Legislative History, pages 5,967. Since 1933, the only asset used by the United States to pay its debts to the Fed have been the blood, sweat, and tears of every American unfortunate to be saddled with a birth certificate and Social Security account number. The U.S. government must conceal this fact from the American people at all cost. Their future labor and tax revenues have been legally pledged via the new all-caps juristic person names appearing on the birth certificate, i.e. the securities used as collateral for loans of credit, thin air belief, to pay daily operational costs, reorganization expenses, and bankruptcy, insure policy premiums required to float the bankrupt government, and interest on the ever-increasing wholly fraudulent debt. All caps legal person versus the lawful being. Just who or what is the all caps person, i.e. John Paul Jones, John P. Jones, or some other all caps letter corruption thereof? It is the entity of the government created to take place of the real being, i.e. John Paul Jones. The lawful Christian name of birthright has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answers as the legal person, the two are recognized as being one and the same under the doctrine of idiom sonum. However, if the lawful being distinguishes himself, herself as party other than the legal fiction, the two are separated. As a result of the federal bankruptcy was the creation of the United States, which was made part of the legal reorganization. The name of each state was also converted to its respective all-caps legal person, ergo state of Delaware. These new legal persons were then used to create more legal persons, such as corporations, with all capital letter names as well. Once this was accomplished, the con began to pick up speed. All areas of government and all alleged courts of law are de facto color of law, color of office, color of operation, color of authority, and color of right institutions. The Circuit Court of Wayne County Court and the U.S. District Court can recognize and deal only with other legal persons. This is why a lawful name is never entered into the records. The all-caps legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is a constitutionally sanctioned common law venue court. Unfortunately, such jurisdictions was shelved in 1938 and is no longer available. The only courts today are statutory commercial tribunals collecting tribute, plunder, by way of privateering from the alleged creditors who think they have conquered the country on their way to ruling the world. If one has enjoyed this content, be sure to like, subscribe, and share this information. If one seeks to support this channel and wishes to see more content like this in the future, we invite you to join the American Badass family by acquiring our limited The American Badass, built on sound doctrines and principles, branded apparel at theamericanbadass.square.site. The American Badass is more than apparel. It's a lifestyle and family of like-minded men and women who take pride in leading by example, who value what money can't buy: integrity, honor, dignity, loyalty, commitment, discernment, discipline, respect, and most of all, family. We create premium clothing inspired by faith, freedom, and hard work, and the principles and sound doctrines that built America. From our family to yours, thank you all for your due diligence, vigilance, commitment, and service in acquiring the knowledge provided herein, standing guard and at the ready to ensure the flame of life, liberty, pursuit of happiness, and enjoyment of property will never be extinguished in the hearts of minds, body, and spirit of man.